all the way.
And chapter 11. No, we didn't finish chapter 11.
We didn't get to do the key terms yesterday.
Yes,
Yeah.
exactly. That's what I'm thinking, because I have to leave early to go work, and I was wondering about the key terms. Thank you.
Yeah,
You're
this-
No problem.
All right, great. I missed too
I
much.
think we got to page 140.
Okay.
Earnest money deposit.
It's just remembering the terms. But some of them are a little bit confusing to me. Like, it's not nothing to do with Victor. It's just me, because Victor is a great teacher. Of course, we all know that. But they're that's why I joined. Like I joined
Not
the
getting
class.
any extra points.
I get confused. And,
Oh, he's here. Everybody be quiet.
No, he was online.
He's the worst. Oh, fine.
He always feels it when we're talking about
I don't know. He knows what we're talking about.
Good morning,
I just
Victor.
get-
Good morning.
Good morning,
Morning.
Victor.
What are the 4 essential elements of a valid contract?
time,
T1.
title,
TTIP.
TTIP.
No, TTIP are the 4 essential, are the 4 elements to have joint tenancy.
Okay.
4 unities. That's the 4 unities you have to have in common for joint tenancy.
Oh yeah, I get mixed up.
So what are the 4 essential elements to have a valid contract, for any contract to be valid?
Competent party.
Competent parties,
Competent
open acceptance, consideration, and legality of object.
Sure. So competent parties, offer and acceptance, consideration, and legality of the object or purpose of the contract. Correct. All right. So the law that says that written contracts take precedence over verbal contracts, verbal agreements.
That is statute fraud.
No.
It's what?
Statute of fraud.
Parole evidence rule. Parole evidence rule. Statute of frauds requires contracts be in writing. Parole evidence rule says that written contracts take precedence over verbal ones. So
Oh, yeah.
the statute of fraud says that contracts have to be in writing, and if it's a lease, how long does it have to be in order for it to be in writing?
2 years or more?
3 years or more, 2 years or more in order to be able to record it.
Oh, gosh. Okay.
A contract that's laid, all the terms are laid out in words. Why am I disappearing? This is not a green shirt. A contract that leaves nothing to interpretation. All the terms are stated in words.
A legally binding contract.
An express contract. It's an express contract. And a contract that's expressed in by one's actions rather than their words is called implied contract. It's an implied contract. A contract where one party's obligated to do something, but only if the other party acts. They have an option.
Unilateral contract?
It's a unilateral contract. A contract where both parties have an obligation to do something.
Bilateral.
Bilateral contract.
A contract with a minor would be
Voidable.
Unenforceable.
voidable.
Voidable.
It's voidable by the minor. A strict deadline in a contract that must be met.
Time is of the essence.
Time is of the essence. A contract where neither party can sue to force performance.
Like contract, but it's not a contract at all.
A contract where neither party can sue to force performance. That's unenforceable. That's unenforceable.
Okay.
If neither party can sue, then it's unenforceable, right? I don't know why I'm disappearing on the screen here. All right. A lawsuit forcing one person to carry out the terms of the contract as they agreed.
A valid contract?
No, a contract forcing somebody to carry out the terms that they agreed to.
Undue influence? I don't know.
No.
You don't.
Specific performance. They had not performed, you're suing them to specifically perform to carry out the terms of the contract as they had agreed to in the contract.
Novation?
No, I just said specific performance. Specific performance. Right? What is novation?
When you
In the contract, changes, modifications in a contract.
substitution, when you substitute a contract with another one.
Correct. It's substitution of one contract with another, or substituting a person named in a contract with another. Hold on one second here. This video is really annoying me. Let me do something. Okay. So a strict deadline in a contract. A strict deadline in a contract is time is of the essence. Substitution of one person in a contract for another is novation, or substituting a person named in a contract for somebody else. That is novation of the parties, or still novation. What's the wording that needs to be at the top of the first page of a contract prepared by licensees?
Legally binded. Legal binded.
This is a legally binding contract. And an amount of money agreed to in advance to serve as compensation if somebody breaches the contract.
Earnest money.
Breach of contract.
Earnest money deposit. I don't know.
Earnest money is any money that somebody puts down. That's all that is. But what do we call an agreement for the amount of money that's to serve as compensation if somebody breaches the contract?
Compensatory damage.
Liquidated damages. It's liquidated damages. And what is the statute of limitations to recover real property?
6 years. 6 year period.
Well, 6 years is mortgages, cases of fraud, contracts, but to recover
2
the
years.
property, it's 10 years.
10 years.
To actually recover the property, it's 10 years. And what needs to be the cover page of any contract prepared by licensees?
The Attorney General memorandum.
The opinion 26 notice.
The opinion 26 notice that tells them before they look at the contract that you have the right to hire an attorney. What do we call it when the broker mixes their own money with their client's money in the escrow account?
Commingle.
And in contract negotiations, when is an offer considered accepted?
When all the parties agree on the price. No, when everybody signed the contract.
All minds are
both sign and deliver.
Meeting of minds.
When both parties they know no matter is
Offer and acceptance.
Think about it for a second. Forget about fancy terminology. When we're negotiating a contract, when is the offer considered accepted?
when the person is notified. When the person notified the other person of acceptance.
The meeting of the moment.
when the person who made the offer had been notified that their offer had been accepted.
Ah.
Do they need to get it in writing?
No, it can be
No.
non.
Not right away.
No,
It's
Can be
contract.
verbal,
It
but
has to be. It's
No,
by mouth.
It could be verbal as long as it's recommended that you follow up with getting it in writing. But no, I don't know what the hell's going on with my shirt. Why is it that I gotta keep it?
yeah.
Hey, we
I
got
just see a floating head on the screen.
Yeah, I know. I don't know what's going on over here. I gotta get closer to this.
Yeah. I just saw a floating head. And
I mean, it must be
Second
thinking that my
Amendment.
shirt is green or something. Oh, my shirt is black. I don't know.
It looks like me.
All right. What is the purpose of the special addendum clause that must be added to all sales contracts if the financing is coming through the FHA or VA?
That is contingent
Contingent upon what?
upon the lender's approval.
Not the lender's approval.
The buyer's approval.
That the house appraises, that the property appraises for the purchase price. And if it does not, that the buyer can get out of the contract without penalty. Okay. So the purpose of the special amendatory clause that's required to be in all sales contracts when the financing is coming from the FHA or VA loan, it says that if the property appraises below the purchase price, the buyer can get out of the contract without penalty. Who does a kick-out clause protect? Escape clause, kick-out, knockout.
It protects the seller.
It protects the seller. All right. And a type of seller financing where the owner does not turn over the deed to the buyer until the full amount owed is paid.
Land contract.
It's a land contract. Now, even though that buyer's not an owner of the property yet, they do have an interest, a financial interest in the property. What do we call it?
Equitable title.
We call it equitable title. It's called equitable title. Correct. All right. What are the three legal forms of consideration? Consideration is what the parties give in exchange. It's
Legal tender.
legal tender.
Exchange of value.
Exchange is something of value.
Love and affection.
And love and affection. Correct. Who could prepare contracts with options in them? Option agreements.
Attorneys.
The seller.
Only attorneys can. Only attorneys can. All right. A type of listing that we get paid no matter who brings the buyer.
Exclusive right to sell.
Exclusive right to sell. A type of listing that we get paid only if if a type of listing we put in the MLS and we get paid only if we bring the buyer.
Open listing.
That's exclusive agency. We only put listings in the MLS that are exclusive. Open listing is type of listing where the owner's free to list with as many agents as they want, all acting as their agents. I suggest you guys make those flashcard lists up and start studying them flashcard lists. You know, the terms and definitions. Like somebody was saying when I logged on and I was eavesdropping on you. You guys really need to study these terms. Okay, it's mostly terminology in exams. Got to study them. It's a lot of terms. All right. Let's continue on. We're actually still behind. So let's continue on here. If we don't finish this all by tomorrow or by Friday, which I have a suspicion. Wait, what is today? Today's Thursday. So today, tomorrow. So I don't know if that's going to happen. If that's the case, looks like we're going to be finishing going into Monday.
Yes.
All right. So in chapter 11, we're done with chapter 11. We finished it up. However, let me see. We finished up chapter 11. We went through the entire slideshow here. However, I want to go over the contract itself with you guys real quick. Go to the first page of the sales contract on page 142. Now, there's a couple things you need to prepare for the contract. What I would say to write at the top of this page here, first of all, you're going to have 2 links open. Every MLS is going to give you access to a tax record system. I showed you the tax record system already, and I made this tiny URL for it to get access to a free tax record system. And here is the links to the contract form system that we use for preparing our digital contracts. So what I suggest is taking these 2 links and opening them up first thing. So type these 2 links at the top of your, or write them at the top of this first page of the contract here. In the margin all the way up to the top. These are 2 things that you should open up first, because you should always have the tax record open, because you're going to need to get some information from the tax record in order to prepare the sales contract. So other things needed in order to prepare the sales contract, you're going to need the contract form system open. You're going to need to have the tax record open. You're going to need to print up either the MLS listing, or you're going to have the MLS window open. So you're going to have a couple windows open on the, on your computer at the same time there. You're also going to have to gather the license numbers of all the agents and their brokerages. You're going to have their addresses, phone, fax, all that stuff. So it's not a bad idea to also have the database open, or the website open for the real estate commission, where you could search people's license numbers. Let me look in the links folder real quick. I'll give you guys a link for that. Just want to pull it up. So that real estate licensee database, we're going to want to have that up too. Which is this page. Remember this page that you go to and you search for people's license numbers?
Yes.
Yes.
That's where you go to see if your license is active yet. You look up your name, and because the contract law now requires that in contracts, you're going to have the employer's reference number, the agent's reference number, the address, their brokerage, the broker's license number, all that information you're going to have in order to put it in to prepare the contract. So this is another window you're going to have open. All right. Now, I'm pretty sure I once made a tiny URL for it. I think I have a domain name for it, but you know what? Let's make up another tiny URL right now for it. tinyurl.com. Let's paste that link in here. And what do we want to call this? NJRE license search. NJRE license search. How about that? Or is that too long? NJRE license search. Is that good to have for the domain? For the searching for people's licenses?
And
Yeah, let's use that.
Yeah.
So there's the domain then. And we can just, let's paste it in, see if it works. NJRE license search. RE for real estate, you know. Yep, takes us there now. See? So we just made a tiny URL. So I'm gonna add that as a shortcut. The NJ real estate license database. Now we have that tiny URL there, okay? And I'm gonna add that to our slideshow. And let's go back to the slideshow. So I'll just add that there. The NJ real estate license database search. Okay, this is the link that we got for that we just made up. Let's shrink this down a little bit. Doesn't need to be that big. All right, so there we go. We just made that little link there for you guys so that you could search for database. You're gonna need those numbers when comparing a contract.
Excuse me.
Mortgage commitment letter. You're gonna need a copy of the mortgage commitment letter from the lender because you're gonna have to send that over. Well, you may not have a mortgage commitment letter yet, but at least you may have the pre-approval or pre-qualification letter, okay, to send over. So the mortgage commitment letter is to be produced 30 to 45 days from the date of contract. But right now, when you're submitting this offer, another thing that you're going to need, that you should have, though, is that, what I say, the pre-qualification at minimum and pre-approval or pre-approval letter. From lender. You should submit that over along with the contract, showing at least that the buyer has had at least a preliminary qualification check. You're asking the seller to take their property off the market and accept this offer. Well, you should make sure then that at least that they have some sort of a check was done on them to ensure that they could qualify to get the loan, right? Yeah, after all, asking the seller to take their property off the market. And then a couple things to know. Here are the dates. The mortgage commitment letter, we're going to have to put a date on the contract for that. The mortgage commitment letter should be produced 30 to 45 days from the date of contract. Make sure the date is a business day from the date of contract. Ensure date is a business day that we put on the contract. But we count calendar days, okay, 30 to 45 calendar days. So ensure the date is a business day that we put on contract. Closing date is typically going to be 45 to 60 days from date of closing. So over here, I'd usually just put 60 days, okay? Over here, I would just put 45 days, give us plenty of time. But 30 days should be enough time for us to get a mortgage commitment letter too. So 45 to 60 days from date of calendar day. If that lands on the beginning of a month, here's a little tip for you. Push it forward a few days to be at the end of the month, because mortgage companies, lenders, they're going to want to get their month-end numbers in. And so they'll try to push those contracts through a little bit. They'll try to push those loans through. If you got a loan that's scheduled to close at the end of the month. All right. Never leave a line blank on a contract. Worst case scenario, fill it in with NA for not applicable. Okay. Loans, if it's a FHA loan or a conventional loan, the minimum down payment requirement is 6% and 3% respectively. So let me just put that there as another point. You have to put down the required amount, the minimum amount that the borrower, or the amount that the borrower is planning on putting down. And the loan would dictate that. So contract must state the amount of down payment buyer is making, as well as the good faith deposit which is customarily $1,000, right?
Yes.
Customarily. Whoa.
Victor, I was told that you could put down as little as $1. Is that true?
You don't have to put any money down, and it's still a valid contract if you don't put down any good faith deposit. But like I said yesterday, you know, if it's my listing and you're putting nothing down, I'm wondering what's up, and I'm going to caution the seller about accepting that offer. So I suggest you go with what is customarily done, so you don't raise any eyebrows, right? Because it may be strange. Why don't you want to put down at least $1,000? You're gonna have to put down more money than that. Why don't you want to put down $1,000? Makes me think you're making offers on several different properties and seeing what sticks. That you're not committing to this property. You know, why is it that you're not wanting to put down $1,000? You don't have $1,000. You're gonna need a lot more than that to buy this house. So there you go. So contracts must state the amount of down payment the buyer is making, as well as the good faith deposit amount. Customarily $1,000. If it's an FHA loan, we're going to say minimum down payment is related to the type of loan. It's, you know, the type of loan would dictate that. So the lender would dictate it as well. So minimum down payment for type of loan are, if it's a FHA loan, 6%, conventional loan, this ain't right. What is that about? Okay, so for FHA loan, minimum down payment is 3.5% with a max seller concession of 6%. But I believe we have another slideshow that says that. Let me just take a peek what the other slideshow says. Anyway, the minimum down payment on a conventional loan, well, it depends on the lender and a lot of other factors, but it's typically 20%. Could be as low as 3%.
First-time buyers get a, what is that, a 3%, is that, if I'm correct?
Depending your credit.
No, unless there's some kind of first-time buyer program that you're working with, there's no There's no special treatment for somebody because they're a first-time buyer.
Okay.
Okay. So unless you're hooking them up with a special type of loan program.
Right.
All right. This is what it is. Now, I'm going through this because this is some of the stuff that we're going to have to fill out in the actual contract, and we will fill this out here in the book. So the sales contract continued over here. I got it all on this page. So mortgage down payment minimum. Conventional loans typically 20%, but can be less. FHA is 3% down. VA loans are no down payment requirement. Loans to veterans is 100% financing. However, the lender still may require some kind of down payment because these are programs, but you know, FHA and VA, these are loan programs, but they don't FHA and VA doesn't lend money. You don't get the money from them. You get the money from the bank. So the lender still may require some kind of a down payment amount. Now, what is a concession? The concession is anything that the seller gives up, is anything one party gives up to another. A seller concession is money given to the buyer to help pay for closing costs and or repairs. The maximum seller concession allowed for an FHA loan is 6%, and for a conventional loan is 3%. I believe it's FHA and VA.
Oh, that's what I'm gonna be asking because
It's maximum. That's like you're asking the seller to help give some money to help them with closing costs, you know. You're asking for them to give that money back. Okay. Then we call that a seller's concession. Okay.
All right.
So that's called a seller concession. All right, so let's see. These are the down payment amounts. This is the, okay, so we could actually just have that on a separate slide. We don't need to have that on here. And this way, all this text can be larger.
Hey, Vic, I have a quick question.
Yes, sir.
Is it standard for there to be an upfront premium for FHA loans?
The mortgage insurance. Yes, FHA loans are required to carry a mortgage insurance called MIP. It's an one-time upfront mortgage insurance premium that has to be paid, which insures the entire loan amount in the event the borrower defaults. However, these are government programs, and even though they require a one-time upfront mortgage insurance premium, you don't have to pay it up front. You could actually build it into the loan and finance that upfront fee itself as well. It's government, you know. Some things they do don't make sense, you know. You could finance the upfront mortgage insurance fee that would cover you in the event that you defaulted. But if you default and you're financing that upfront mortgage fee, then it wouldn't have really been paid anyway upfront, right? So that's kind of it's kind of dope. Yeah, it's government, you know. Not exactly the most efficient, well-oiled machine out there, you know. All right.
Yeah, that's for sure.
All right.
Running on rusty parts lately.
Yeah. So we got this. Why do we print out the tax record for the property? Why are we pulling that up? Well, because we're going to need to get the lot and block number, find out who the owners are, their address, all that stuff, you know. Sometimes, you know, it'll say on here if they're an absentee owner, that means that they don't live at the property, this particular property that they own. So on the top of page 142, just write these two domain names because you're going to need those opened up. You're going to need those windows opened up. Hey, what the heck? You can write this one there too because you're going to need to search for the license too. So those are three windows you need to open up right away. So why don't you write those domain names there? You know, njrforms.com. This is, by the way, a domain name that I bought, and I just pointed it to the New Jersey contract form system. This one I created called tinyurl.com/NJ tax records. But every MLS will have its own tax record system that you could open up. And then you're going to want to print a copy of that MLS listing. And you're going to need to open up that real estate licensee database at tinyurl.com/NJRE license search. Okay. tinyurl.com/NJRE license search. And you guys
You
saw me.
abbreviated the license, just the way how we see it is how you put it, right?
Yep, just the NJ. Well, no, the license, the full word is spelled LICENSE. You see it?
Oh, okay, yeah.
So it's NJRE license search. So that's the full domain. You guys just saw that I just made it on the screen in front of you. All right, so you know where it points to. I pasted the link there. I showed you where it opens up. Okay. All right, there's so you need to get this pre-approval letter from the lender as well. You're going to need that. If the property is
Vic, is this the necessary or the compulsory to get the pre-qualification, pre-approval letter of the lender?
Yeah, when you're sending an offer on a property, you need to make sure that that person either has the funds if they're buying cash. If that's the case, you're going to need to forward along a, let me see. I don't have it on here, but you know what, I'm going to take one of these bullet points.
No, what I mean is it is required by the law or it is just the agencies they want to cover? Not to waste time for that. They want that.
No, it's required. It's required. We have to do some kind of check to make sure that the person qualifies for the loan. We got to treat everybody fairly and honestly, and we can't be trying to waste the seller's time. So we have to forward along some kind of search. We have an obligation. Remember, we're responsible for our client's money and or property, but we need to let other people know as well if they qualify for the loan. So at minimum, we need to have a pre-qualification letter or a pre-approval letter that we're going to send along with that from the lender. Or if a cash purchase, they're not bringing us a duffel bag of cash.
Bank account.
We will need a what we call a proof of funds letter from the bank where they got their cash. I don't need to know how much cash you have in the bank, but I need to know that you have enough to complete this purchase. So we're going to need a proof of funds letter from your bank. You know, some people are like, money's not a problem. Really? Money's a problem for everybody. Last I checked, millionaires, money's a problem. You know,
really.
Their purchases are just on a different level than ours. But everybody's money's always an issue. So somebody that tells you, I got it, man. You don't got to worry about money. Money's not an issue. You know what? You're full of shit. Money's always an issue. I don't care who you are. Money. You know.
You're so right. It's so right.
So, I mean, you could talk to people like that too. You know, let them know. You know, money's always an issue. So if money's not an issue for you, then you shouldn't have an issue getting a proof of funds letter from the bank manager, right? You know, you can word it that way to them. You know, hey, okay, great. So then you shouldn't have a problem getting that proof of funds letter from the bank manager. Okay, I mean, I don't know you, right? You say money's not an issue. Show me. You know.
Show me the money. Show me the money.
Because that money has to have been in that bank for at least 2 to 3 months. It needs to be seasoned, right? Remember I talked about seasoning of funds?
Yes, sir.
Make sure that those funds weren't coming from your drug dealing, gun dealing, prostitution, human smuggling, or any kinds of other nefarious means, right?
Yep.
There's something else I wanted to add. Oh, so another thing that you're going to need to get, if the property was built prior to 1978, you're going to need to get the lead paint addendum, right?
Yes.
So if it's a pre-1978 property, you're going to need to have that that lead paint addendum letter. It's also not a bad idea to get the seller's property condition disclosure report. All right, you're going to want a copy of that seller property condition disclosure report that was already filled out so that you could go over with the buyer. Now, that seller property condition disclosure report, what page is those on? What page was that on? Oh, I think it was on page 123. Yeah. Page 123. All right, so these are some things that you're going to need to get together before you ever start putting together that contract. I can take this last line and stick it on the next slide. All right, so this is all the things that you need to put together, you need to have together before you're putting together the contract. So how much down payment is required if it's an FHA loan?
Minimum 3.5%.
3.5% to 20.
Minimum down payment,
3.5
right?
to 6.
It's your mortgage down payment minimums, okay? So now the buyer can put down more if they have it, you know, but these are the minimums. If it's an FHA loan, 3.5%, conventional loan, typically 20%, but it can be less. I've seen it as low as 3%. Okay, depends on a lot of factors to the lender, depends on the risk. That's why they call it risk-based lending, all right? VA loans, they typically require no down payment. 0 down payments required. However, the lender may still require some down payment amount. And because the VA doesn't require the money to be put down, you know, they'll get that money back at closing, or it'll be credited towards their purchase price. That's how that would work. Okay. So these are the mortgage minimum down payments if it's a conventional, FHA, and VA. Okay. So let's put together this contract in the book, and we're going to say that we're going to be buying a $300,000 property using an FHA loan. So in order to do that, see how these lines, they pretty much tell you what to fill in the blanks. On these, let me just mute this for a sec. These lines pretty much tell you what to fill in. You have, look, lines 18 through 20. That's where you put the buyer's information for up to 4 buyers. If you got more, you can put their info on an attached form and just note it here. Whose addresses are, and you on line 22, 23, that's where you put their addresses. And they agree to purchase from, then there's 4 lines there for putting 4 sellers' information down. Whose address is, and you fill that in on the next 2 lines. You see, it pretty much tells you what to put on the blank lines.
We're not seeing what you're actually speaking of unless you're
in a book, right? You're on page 142 in the book.
142.
Yeah. Okay. We're good.
Okay. We're not seeing it on screen. We're seeing it on the book. You there?
Got it.
Okay. So on line On line 36, you're going to put the subject property in there. In line 38, you're going to show the municipality name. You're going to put the name of the municipality, you know, the city, town, township, borough, what have you, followed by the county. I want you to highlight that line that says county. Do not leave that blank. Don't be lazy. Go to Google, put in the address, and try to find out what counties, you know, because we have multiple municipalities in the state of New Jersey that share the same municipality name, but they're in different counties. We need to be accurate then and put down the county name there too, so two properties cannot be confused that are in different counties in New Jersey. You have to fill that out for the property in question. Okay. Then the lot and block number, line 40, you'll get that from the tax record and or the MLS, which you should have both of them open up, both those windows. Now, total purchase price, line 44. Write $300,000 on that line. See all the way to the right, blank line, dollar sign, put $300,000 there. The line beneath it should be for the initial deposit that the buyer's putting down. So write that there, $1,000, right? Write $1,000. That's your typical deposit money. So we'll put that there. And then the line beneath it, that's your additional deposit. Well, if it's an FHA loan, they got to put down 3.5%. Uh-oh. Huh. All right, so if it's an FHA loan, you put down $1,000. It's a $300,000 house. You already put down $1,000 for the first deposit. How much more money does the buyer need to put down?
8,500.
Another 9,500. Because 3.5% of 300,000 is 10,500. So you already put down 1,000. So they need to put down another $9,500. So write down $9,500 there.
And that's in the additional deposit?
Next to additional deposit, correct. And then the line below that is the mortgage balance. How much mortgage loan are they going to need to qualify for?
289.
$289,500.
100.
So put down $289,500. So put down $289,500 on that line. And the line beneath it, the balance of the purchase price will then be zero because there's no more money to put down. That line would be if they didn't have that $9,500 to put down as the complete second deposit. Then they were going to put it down. They're going to bring it to closing. So that balance of the purchase price is any money that they would need to be bringing to closing still.
Victor, is all of this normally done on the computer and then printed out and then get the signature? So
Yeah,
that
I
way
mean, you can print it all out and then write it in, but yeah, it's easiest to do it on computer and then print it out from the beginning.
Yeah. Some people have chicken scratch, that's why.
Yeah, That's why I like to do it that way, because even if you sometimes, if you're rushing, even if you got nice handwriting, usually, you need to make sure that this stuff is legible.
Legible.
Yeah. Hmm.
Okay, what is the balance of the purchase price? Means what do we have to write? I mean,
289,500.
Well, no, the balance of the purchase price at the end would be zero.
Yeah.
Like I said, that was any additional money that you need to bring to closing.
The 289,500 goes where the mortgage.
Well, it goes underneath the mortgage. It goes underneath the
Yes.
mortgage amount.
Yes.
All right. And then don't forget that the last two lines there at the bottom of the page are for the initials. Highlight those. The buyer and the seller need to initial the bottom of every page of the contract.
That's initial on any page and anything after they change it, all right? Any correction they make it?
The prorations are not here. We don't do prorations. The closing agents do prorations. So this is what we're doing here is on this page, we're just we're putting down the basics of the contract. This is for the contract that we're going to be putting together and then presenting to the seller. All right, so we're putting this contract together so that then the buyer would sign it, and then this is the contract we would present to the seller to see if they even accept it yet. So this is just at the beginning here. Okay. So yeah, let me give you a little example. So I'm in the contract form system here. You guys see this? I'm in the New Jersey. I'm in our zip forms. Our New Jersey. This is what happens when you type in njrforms.com. You come to this place. So
yeah,
the very first form over here, I set up the contract of sale. The very first thing that we put in here is, well, I'm going to be filling this out for the buyer. Let's just say I'm only representing the buyer. I'm going to check off I represent the buyer, not the seller. Right? And then, of course, you put the buyer, the seller's information here, the buyer's information on this side. The listing agent puts their info on this side, and the selling broker, that's the one who's representing the buyer, puts their information on this side. And the name of the licensee who prepared this contract, that would be you. You put your name here. Okay. Scroll down a little bit. That's where you put down all the sellers, you know, all that information that should be carried into here, you know, automatically, the buyers and sellers information. Then you put their addresses on these lines, right? You put that purchase price here. In this case, it would be $300,000. Then the next line, we put down that $1,000. Then the next line, we put down 9,500, right? And then the following line, we put down 289,500, which was the balance of the purchase price. Okay. Nope. And then the balance of the purchase price is zero, actually, because it goes down here. See, if we only put down 8,500 here, you see it automatically calculates this for us here on this form. It would be $1,000 that they would need to bring to closing. If they only gave us an additional 3,500, you can see it's $6,000 that they would need to bring to closing. Okay, so you see how that works? but they gave us that balance at 9,500. So now it's zero that they need to bring to closing. Make sure that the buyers and sellers initial the bottom of every page. Do not leave blank lines on a contract. Okay. The initial deposit money to be paid by buyer to listing broker, the participating broker. Well, we are the participating broker if we're the buyer's agency. Or they could give that money to the buyer's attorney or the title company. But in this case, they gave it to us. On or before, then you put down the date they gave it to us. Any additional deposit, that would be that $9,500. When do they need to give that to us by?
Closing.
All right, and we're going to put a date on this line now. For the additional deposit, I like to put down within 10 days after attorney review. Over here, if you leave it blank, it says within 10 days after fully signed contract. I just write down within 10 days after attorney review, because the date's 10 days from the attorney review versus 10 days of when they signed the contract could be two entirely different dates, all right? So this way, I'm not going to require them to give me that $9,500 unless we know for a fact that the offer's been accepted and it went through attorney review successfully. Attorney review can be longer than 10 calendar days after they sign it. So I'm going to make sure it's 10 days after attorney review. And the trust account, I'm going to put down the name of my brokerage here because that's who took it. So I'm going to put down the name of my brokerage. The type of loan, let's see the principal amount. How much loan do they need to qualify for?
289,500.
289,500, right?
Mm-hmm.
And this is an FHA loan, so I checked that.
Mm-hmm.
And the written mortgage commitment letter. When do we want to get? We got to put a date on this line for the commitment letter. When did we say to put that date in there by?
Has to be between 30 to 45 days before after they sign.
Correct. So within 30 to 45 days. So right now, what I'll do is I'll just look at where we are right now, and I'll put it. You know, do I want to rush this or not? You know, so I'll look 30 to 45 days. You count all the days on the calendar. 30 to 45 days, you count all the days. But just make sure that it ends up landing on a calendar day, okay? Make sure it lands on, a business day. Not just a calendar day, but make sure it lands on a business day that's not a holiday, okay? So like, here, let's put down a 12, okay? And then
you're not going to put the terms of the mortgage. The terms you're missing the
the terms of the mortgage is how long is the mortgage? You know, it's 30
years.
Typically, it'll be a 30-year mortgage.
30 years mortgage.
So we'll just write down 30 there, 30 years, and based on a 30-year payment schedule. Okay. Payment of the balance or purchase price shall be at closing, which will take place where? Where's the closing going to take place?
You send the seller's attorney, right?
Entire company.
Typically, typically that closing is going to take place at the buyer's attorney's office, but it could take place at whichever office that they agree on. But right now, I'll just put the buyer's attorney's name there. So I hope you should have that buyer's attorney's information. So you know what? Let's go back to that slideshow. That's another thing that we could add into that slideshow, right? Things to gather. Things to gather would be that, oh geez.
Buyer's attorney.
There's a font size.
Buyers and sellers attorney information. Well, sellers when
yeah, buyer and sellers attorney information. But right now, at the beginning, when you're filling out the contract, right now you just need the buyer's information to fill out the contract, but you do need to get that seller's attorney's information because after it's signed by the buyer, you need to send it off to both sides, right? Information, okay? All their contact names and contact information, you need to gather that up. All that stuff needs to be prepared. Oof. Let me shrink this down. We're running out of room here on this slide. A lot of information we got to gather up. It's a lot of work we got to do. right?
Victor, attorney's information if the buyer has an attorney.
Yeah, they usually do. They usually will. Okay. If they don't, we're gonna ask them who they're using as an attorney, or if we need to get them the who. Listen, even though they don't need to have an attorney, don't be telling people, oh, you don't need an attorney. Listen, chances are the other side's going to have an attorney, so just ask them who you're using as your attorney. Do you need a recommendation at all? I mean, we don't recommend anybody, but we have a list of attorneys that our past clients have used, you know, and we haven't received any complaints about them. So you can use them. You can use any attorney you want, though. Okay, but I'll give them some sample attorneys. It's not an inclusive list by any means. I tell them they can use any attorney they want. We don't personally recommend anybody, but these are attorneys that our clients have used in the past and haven't had issues with. They like them. So we're just making it available to you for convenience purposes. Okay. Try not to buck the system there, because if the other side has an attorney, they're probably going to try, and you don't, they're probably going to take advantage of you somehow. So might as well just get them an attorney. Okay. And now we're not going to fill out this whole contract together, but basically, so you're going to put down, you know, wherever the closing is going to take place. Right now, we don't know where that's going to be. We're going to put down buyer's attorney. You could just write buyer's attorneys here if you wanted to. Okay. And the date, when's the date of the closing? So the anticipated date of closing we're going to put here, which is going to be 45 to 60 days from the date of the contract. Okay. Now, the next section includes any items that are included in the sale. In here, I like to write this. So actually, hold on. Let's back up a little bit. So the additional deposit, if any, I actually write 10 days. 10 days after AR. That's attorney review, because attorney review, yeah, it will fit in there now. Okay. Usually doesn't. Okay, so I write 10 days after attorney review in there. I don't actually put a date, even though it wants a date on that line. Well, they're going to have to figure it out, because I wrote 10 days after attorney review there. Okay. And this is going to go in the trust account of my brokerage name. So I'm just going to, so on here, I would just write my brokerage name. Okay, the escrow account. Payment of the purchase price shall be made on by buyer at closing, which shall take place at. We're going to put down the buyer's attorney's information there. I'm looking for a date here, which would price by buyer shall be made at closing, which will take place on. Okay, so this is the date that they're looking for the closing date here. So I'll select a date here, 60 days from the date of closing. I don't know. I'm just going to pick a random day here, and here we go. Sufficient assets. Oh, okay. Okay, so in here, what is included in the sale? So on this line for included, what's included in the sale, you could either copy and paste everything that's written there in the MLS and in the seller's property condition disclosure report, or you could write each item in, or you could write per MLS number, and then just write in whatever the MLS number is, right? For the property, for the listing, per MLS number. And then you could also add in there, plus any additional items you could add in there that you may want included. And I'll do the same thing over here. So we'll just copy this fake MLS number that I just made up. All right, you can put per MLS number there as well. Or write in, like if the chandelier is not included, you would write that here. So I would write, so I'm going to put in here, plus any, this is just a note for you, plus any, now you should write this in your book in this section, plus any items the listing agent specifically excluded from the sale. That's like if they forgot to put it in the MLS, but they told you that the chandelier is not included. You should write that here so that you could avoid problems. Now you're getting the buyer to sign off on it. You're showing it to them. You're getting them to sign off on it. So it's not going to be an issue later. You're getting the seller to sign off on it too. Okay? So this is how you write it. Per MLS number, you write the number in there, and then you write something like that. Now, certificate of occupancy and zoning compliance. Some municipalities require certificate of occupancy. Closing shall be responsible for any repairs. However, if this expense exceeds what amount? Put $800. That's usually what attorneys are going to write in there anyway. So basically, if the repairs are over $800 for the house in order to get the CO, then the buyer doesn't have, then the seller doesn't have to do them. They could say, okay, you can take it as it is, or we can cancel the contract. Okay. The attorneys will limit that anyway, no matter what you put in there. Municipal assessment. A seller represents that the seller has not been notified of any such anticipated assessments. What's municipal assessments? That's of additional taxes that they're going to have assessed to them. So seller represents that they has or has not been notified. Quality of title. Okay. Property is a 1, 2, 3, or 4 family. You don't put down the number 1. You'd spell it out. 1. Or single. If it's 2 family, write the word 2. Spell it out. 3, 4. You're not going to put above 4. Why?
Because they cannot see anything.
Because we can't prepare a contract for anything above a 4 family because it's considered a commercial. Right? So you would write down here either single family residence or 1 family residential dwelling. Tenancies are not applicable in this case. If it was, then you put down the tenants, all the tenants' names, their location of their unit, how much they pay for rent, what their security deposit is, and what the term is. When is their lease ending? If it is built prior to 1978, you're going to check off applicable. And then you make sure that you also have the lead paint addendum filled out. All right, so after the inspection is done, any work that needs to be done, we got to negotiate between them. They have so many days to respond back of what work that they're going to do. You know, you could just write 3 there, and the other party has 3 days as well to get back to them. Since if you leave it blank, that's what it's going to be anyway. Poet systems, these are for the water treatment. In this case, we're on city water, so it's not applicable. Cesspool, not applicable because we're on city sewer. No cesspool located on the property. All right. So you got to go through all this stuff on the contract. Infestation or damage by wood-boring insects, okay? If it's left blank, this is when those inspections going to be done. When do you want to get that inspection done? You know, well, you over here, if you leave it blank, it says 14 calendar days. So as soon as it gets out of attorney review, you want to make sure that we get that, that we arrange for that inspection to start, okay? Buyer's right to inspection, okay? Once again, 14 days for all this stuff. declaration of business relationships between the party. So if you're filling this information out, well, you already filled this out on a different form. It'll automatically go into there. But let me see. See, if you've done business with other companies before, you can put that info in here. So I'll just check my info, my brokerage license number, all that stuff's automatically going in there. And is authorized representative of, you would put down who you're representing there as the buyer's agent. The other side is going to be the seller's agent. You're going to put down the name of the other brokerage in here. Okay. You can see past brokerages that you worked with, and you'd write them down as the seller's agent, buyer's agent, or transaction broker, however it is that they are working. They supplied that information because we got it from them from the MLS. And then here you got to put down the name of the listing firm and the company name. That's where you get it from having that window open on the Real Estate Commission's website. Same thing for the listing agent, same thing for the participating agent, all the contact information, emails, cell phones, fax numbers, office addresses, all that crap you fill in here. Now, commission due to the listing. If you leave it blank, it says per listing agreement. I like to write it in, because I didn't get to see the listing agreement. So I'm going to write in what it said in the MLS. Now I'm going to assume that the other side's getting an equal amount, and I'm going to write that in here. Disclose the buyer sellers of real estate licensee. Look at that. See, we don't have to actually write that into the contract anymore because they made it part of the contract. So you remember you got to disclose if you're a licensee. So look at that. That's nice. They actually made it part of the contract now itself. So if you're the one that's buying or selling the property, you would put applicable, and then you'd put down your information here and check off your license type. But for now, we're going to check not applicable because our client's not a real estate licensee. Any additional addendums that you're adding here? This is the FHA loan, so we're going to check off the FHA, that it is an FHA loan. We are going to check off that it was house is older than 1978. So we're going to check that off. Any other addendums? We even have a coronavirus addendum now. But any other addendums you're going to be adding in there, okay? Why do we check off coronavirus addendum? What could that possibly be about? Well, somebody was living in that house and they had coronavirus. Could the house have a coronavirus in it? Is there a possibility? Because we got to worry about lawsuits and stuff. They came up with a disclosure for coronavirus. Especially if somebody died from coronavirus, right?
There must be a sanitize the house and everything.
No, we got a disclosure for that, okay? And then make sure that everybody signs it and dates it. We've got a wire fraud notice here as well. It becomes standard. All right. So basically, that's the contract in a nutshell. Okay. So you got to get a lot of information together. Now, there may be other disclosures that we have to put in here. Automatically, it sets up the opinion 26 notice here for us. So let me just go in here and clear off some of the dates that I may have written in here. So all right. I just wanted to do that because I'm going to be printing this as a sample form. So I'm going to print this form to PDF and save it to my computer. So that I can show this form in future classes, okay? So basically, you can either print this form, print it to your printer. In this case, I'm going to select the, I'll just end up saving it, and then I'm going to open up a different, I'll open up a different window. Okay, so we're actually done with chapter 11 now.
Yay.
Was there any other form I said I wanted to fill out from there or no? Anyway, okay, so let's move on to chapter 12. Chapter 12 is going to be a long chapter.
We're not going to do the key.
The key terms.
Okay, we can do the key terms as well.
Please.
It'll be all right. Oh, wait, let me show you also the lead disclosure form. Here's also the lead disclosure form that we usually fill out. You put down the property address, then the seller has to fill out whether they have any knowledge or they don't have knowledge to any lead hazards. And that if there's any changes, that the seller's going to let the other side know that they're aware of any lead if it becomes available or known to them. And then the buyer fills out their portion saying that they received all the information above, they received the pamphlet, and they're going to check off whether they received a 10-day opportunity or they're waiving that 10-day opportunity to conduct that inspection as well. Let me just print that form as well. All right. See, we can see all the different forms that they have available. Yeah, we select the ones from New Jersey Realtors. You could have your own custom versions of forms here, though. You see, there's all these disclosures. If it's a short sale, if they're asking for a seller's concession, lead paint, addendums regarding swimming pools, exclusive buyer's agency agreements. Informed consent to dual agency. You see there's one here for the landlord, one for the tenant, one for a buyer, and one for a seller. Okay. Just want to print these blank ones really quick, save them to my drive here. Yeah. We'll also have one here somewhere about the private well. Let me see which one this is. This one's for the seller. DDA is for the seller. Sorry, just give me 1 second of your time here. Just going to print them out while I'm in here. We got a DDA for the buyer. We have one for the tenant. And then there's going to be one for the landlord. But you see how you could print out the blank forms? You don't have to necessarily go fill them out on this system. You could have them already printed out. That's what I'm doing right now. you know, I'm printing to PDF, but I could send it to a printer as well. Let's see, we got hold harmless agreements for landlords, for sellers. Let's take a look at this form, see what the heck this form says. Yeah, let's print a blank one. I could, so this is COVID for the seller. Basically, you're basically saying that the buyer is going to hold the seller harmless. They're not going to sue them about anything regarding COVID-19 in that house. And they got a version of this for tenants as well. Here's your vacant land contract. You know, so for selling land, it changes up a little bit what's in it. So they got disclosures and contracts for all kinds of issues here, right? All right, let's go to chapter 12.
Key terms.
Key terms.
Thank you.
Can't forget those.
Okay, so for chapter 11, I guess we could do the key terms, right? So at the end of the chapter, this is a long chapter, so there should be 2 of them. Yep, there are. So let's do those key terms for chapter 11, all right? Agreement between 2 parties to perform some legal act.
Contract.
Bilateral contract.
7 is it is a contract. But a violation of a contract.
Breach of contract.
Somebody's in breach. Yeah, 3 is B. Buyer's deposit with the purchase contract.
Earnest money.
Earnest money.
Buyer's deposit with the purchase contract is the earnest money. 9 is C. A certain happening on which a contract depends.
Contingency.
6 is D, contingency. 6 is D. Contract that's put into words but not shown by actions.
Implied
contract.
A contract not put into words but shown by, I read it wrong. Contract not put into words but shown by actions. It is an implied contract. 15 is E. A contract set down in so many words.
Express contract.
14 is F. It is an express contract. A contract that has been fulfilled.
Executed
contract.
Executed contract.
A contract that has been fulfilled is an executed. Executed 12 is G. Contract that has not yet been performed.
Executory.
It is executory. 13 is H. A contract with a promise by each party.
Bilateral.
It is bilateral. It is bilateral. 2 is I. An interest acquired by the buyer with a land contract.
Equitable title.
It is equitable title. 10 is J. Offer returned to the buyer with changes by the seller.
Counter offer.
8 is K, counter offer. Protection for the seller when the buyer has another house to sell.
Escape clause.
Escape clause, also known as a kick-out or knockout clause. 11 is L. Something of value given in exchange.
Consideration.
Consideration. 5 is M. And you guys know the 3 forms of consideration.
Love
and affection,
tender,
and exchange of something of value, and legal tender. Correct. So those legally qualified to enter into contracts.
Competent parties.
Competent. They are competent parties. 4 is N. A transfer of interest in a contract to a third party.
Assignment.
1 is O, assignment. And an agreement under which the buyer pays in installments and waits for the deed.
Land contract.
Land contract, 16 is P. I want you to write next to 16 over there, seller financing, or you could write, see, installment sales contract. A contract binding one party, the other party is free to act or not.
Unilateral.
No,
What
but
are they describing? When a contract is binding one party, but the other party is free to act or not. What are they describing there?
Option?
They are describing an option. 4 is A. Seemingly valid contract, but neither party can sue to force performance.
Liquidated damage.
Unenforceable contract.
An unenforceable contract. 11 is B. A contract clause requiring punctual performance.
Time is
Time
of
is of the essence.
Time is of the essence. 10 is C. A return to the status quo. That means returning to the way that you started.
Recession?
Rescission. 6 is D. A contract that does not meet all requirements.
Oh, void contract.
void.
14 is E. It's a void contract. 14 is E. A contract that is binding, but one party may disaffirm it.
Voidable contract.
Voidable. 15 is F. A contract that meets all the legal requirements.
Valid contract.
13 is G. It's valid. Court action, usually asking that the seller be forced to sell as agreed.
Oh, specific performance.
7 is H. Specific performance. Time within which one is allowed to assert their legal rights.
Which one's allowed to assert their legal rights?
Statute of limitations.
9 is I. It is the statute of limitations. A law requiring certain contracts be in writing.
Oh.
Number 5. Parole evidence rule.
No.
Number 3.
Oh,
Offer
no,
and
number 8 is
acceptance.
not.
Statute of frauds. 8
Statute of fraud, yes.
8 is J. Well, think about it for a second. A good way to try to
Like a law.
remember this, listen, a good way to try to remember this is to prevent contract fraud. Isn't it better to have it in writing than verbally?
Yes.
So
Yes.
the law that requires things to be in writing would be the statute of frauds to try to prevent fraud. Does that make sense? To try to maybe remember.
Yes, sir.
Okay. So 8 is J. A one-sided promise valid only if the other party acts.
Unilateral contract.
It is unilateral. 12 is K. A convention that a written contract overrides spoken promises.
Novation.
Evidence rule.
Parole evidence rule. 5 is L. And think about this one. You know, if one person has a contract in writing and another one has a verbal contract, which one can you prove? Which the one that you have evidence on? So the parole evidence rule. You know, one with in writing, right? So that's what the parole evidence rule is. It says that written contracts take precedence over verbal ones. You have evidence in that. So it's the parole evidence rule. So that was 5 is L. Substitution of a new contract for an existing one.
Novation.
2 is M. Novation. A sum agreed on to serve as damages in case of future.
Liquidate damages.
1. Liquidated damage.
Yes, liquidated damages. 1 is N. And a meeting of the minds.
Offer and
Offer and acceptance.
3 is O. There we go. All right. All right, so let's see. So, chapter 12. This is going to be a long one. And so let's get ready for it. Okay.
They're popping.
And here we go. All right. So chapter 12. This is the chapter about leasing properties, landlords and tenants. So at the end of this chapter, you're gonna be able to explain a lot of stuff. We're gonna be covering a lot of things about the different types of leasehold estates, provisions in leases, eviction, truth in lending laws, disability laws. Let me see, discussion between various types of leases, functions of property managers. We're gonna go through all that stuff now. So we're going to first start off by highlighting on page 160 that a transfer of property by lease is known as demise. So under leasing real estate, in that end of the first paragraph, last sentence, a transfer of property by lease is called demise. Every lease has a demising clause in it that says that the landlord is to let the property, let is short for lease, the property, and the tenant is to take possession of the premises. Now, what is a lease, basically? A lease is a document where an owner intentionally transfers their interest in their property for a limited period of time to a tenant, except for the right to sell it, right? So New Jersey statute of frauds requires leases to be in writing if they're how long? We went over this in the last chapter.
2 years.
More than 3 years.
If it's 3 years or more, it has to be in writing. If it's 2 years or more, it can be recorded. So under the fourth paragraph, third paragraph under leasing of real estate, I want you to highlight the New Jersey statute of frauds stipulates leases for a period of more than 3 years must be in writing. A lease may be recorded if it's 2 or more years. All right. So a lease is considered to be intangible personal property, because the owner is transfers the right of possession from the owner of the real estate, who is the lessor, to the tenant, who is the lessee, for a specified period of time as defined in the lease. So what kind of property, what kind of asset is a lease?
An intangible.
Intangible personal asset. Intangible asset, it's personal property, intangible asset. Here, let's do it that way. I got this kind of mixed up here. Let's keep it straightforward. It's an intangible asset, which is considered personal property. Where an owner intentionally transfers all their rights, or most of their rights, or actually the right of possession, but also most of the other rights as well. Most of their rights of possession so where the owner, who is the lessor, intentionally transfers most of their rights of possession to the tenant, who is the lessee.
So this isn't like a case scenario if I own a property and I'm leasing it out.
Yeah.
I'm renting it out.
Yep. Yeah.
Okay.
So a lease is considered an intangible asset. It's personal property. The owner, the lessor, intentionally transfers most of their rights of possession to the tenant, the lessee. Most of their rights. Like the right of possession to the tenant, the lessee, for a specified period of time as defined in the lease. There we go. I like that list better. It's more straightforward. And the demise, every lease has a demising clause that says that describes the transfer of property by lease. The landlord is to let the premises and the tenant is to take possession. So every lease has a demising clause stipulating that, okay? And the lease is both a contract and a conveyance in that a lease is the contract that defines what exactly is being transferred to the tenant, and it's a conveyance in where that the landlord is transferring their property to somebody else. So we have different types of estates in land. What's an estate in land? You guys recall that? It describes or defines the amount and kind of interest that someone has in real property. And there's two categories, just to do a recap. We have freehold estates. So freehold estates describe ownership. And then we have leasehold estates, which transfer an owner's right and interest in the real estate they own to a tenant for a limited period of time as defined in a lease. It's an intangible asset that is considered personal property, just like we said on the previous slide. So we're going to go over the 4 types of leasehold estates right now. You know what? I should have a slide. You know, if we're going to be doing this, we should have one slide at least, I guess, at the beginning that shows the 4 types of leasehold estates. 4 types of leasehold estates. Okay. So I'm just going to have a list. I'm just going to have a list of them here, and then we're going to get into each one of them. So we have an estate for years. Let's see, what order do they go in the book? Estate for years, periodic estate, also known as period to period. We have a tenancy at will, or estate at, I'll call it estate at will, / tenancy at will. And we have a tenancy at sufferance, or estate at sufferance, estate / tenancy at sufferance. All right. These are the 4 types of leasehold estates. So next, let's go over those estates. The first one is an estate for years. So what is an estate for years? Don't let the name fool you. It does not need to be for a period of years.
Period of time.
It's for a definite period of time. It does not need to be for a period of years. It can be for 1 week, 3 months, 1 year, 2 years, 1 year, etc. Okay. The key characteristic to it is that it's for a specific period of time. Specific / fixed period of time that has a beginning and end date. Okay, has a beginning and has a beginning and end date in it. so, mute that.
Somebody in the bathroom? Jesus.
All right, so let's mute that. Let's see, specific.
That was hilarious. I'm sorry.
All right, guys. Hold on. So it has a beginning date and an end date. It's for a specific period of time, has a beginning and end date in it. You know when the term will end. Okay, so that's the key characteristics to it. You know, so don't get fooled by when you hear an estate for years. It need not be for years. Don't be fooled by the name. It doesn't have to be for a period of years. So it's for a definite period of time. Does not need to be for a period of years. Can be 1 week, 3 months, 1 year, 2 years, etc. Okay. It's for a specific fixed period of time that has a beginning and end date in it. You know when the term will end. If you know when the lease term ends, it's an estate for years. No notice is required to terminate at the end of the lease. No further notice is needed. Why? Because it has an expiration date. There is an expiration date because it has an expiration date. If the tenant doesn't renew, they must vacate at the end of the lease term, right? You either renew or you leave. We don't need to give you any further notice. When the lease ends, that's when you got to go, unless you renew the lease. Make sense?
Yes, sir.
I think so.
Yes.
Yes.
Okay. So that is an estate for years. So in the book, you guys highlighting estate for years has the first sentence, a leasehold that continues for a definite period of time with a specific termination date has an end date. Termination date is an estate for years. Skip the next sentence and then highlight the third sentence that says no notice is required to terminate such a lease at the end of the term.
Where we at again? My apologies.
Under estate for years, under lease terms, leasehold.
Page 161.
Leasehold estates, estate for years.
Okay, highlight estate for years.
First sentence, and then the third sentence that says no notice is required to terminate the lease at the end of the term. Now, of course, rent is due at a specific time. You know, when is rent due? Whenever the landlord, whenever it says in the lease, right? So rent is due at specific intervals, just like any lease, okay? So we could add that rent is due at specific intervals. Per the lease. The lease will tell you when the rent is due, right?
Yes, sir.
And anyone who terminates a lease early is in breach of contract, right? But that applies to any type of lease. So I should write that where we got our list of the 4 types of leasehold estates. Rent is due at specific intervals. Per the lease, anyone who terminates a lease early is in breach of contract. All right. Stayed for years for a fixed period of time, has a specific end date in it, and no notice is required to terminate the lease at the end of the term. periodic estate. A periodic estate is from period to also known as a lease from period to period. Its distinguishing characteristic is that it automatically renews. It has a date in it, okay? It has a date in the lease. Has a date in the lease.
Victor, when you says this automatically renews, are you saying that let's say 1 year from date to date, and we have a periodic estate lease, it automatically reviews at the end of the year, and at the start of the new year, the lease automatically takes into effect for another whole year?
It automatically renews for the same amount of time the lease was written for. See the first one there, the first bullet point? It has
Yes,
a
sir.
date in the lease when the lease, it has a date in the lease, but this is it has a date in the lease. It's a renewal date. The lease will automatically renew for the same amount of time the original lease was written for. Unless we look at the next bullet point, either party may give notice to quit, to terminate. However, how much notice to terminate depends on the term of the lease.
Some property owner acts anywhere for like 30 to 60 days notice if you're gonna not renew it.
Well, a periodic estate works like this. If the lease is for a period of, if it's week to week, landlord has, the tenant has to give, tenant or the landlord has to give 1 week's notice to terminate. So what we're going to do here is we'll just write, if it's week to week, 1 week's notice is required. Month to month, 1 month's notice required. If it's a period of years, 3 months notice is required. So basically, if you have a lease for a year or more, the landlord will send out, landlords will usually send out to you a renewal notice, right? However, if it's a periodic estate, they don't send anything out to you. You as the tenant have to notify the landlord whether you're going to terminate the lease or not. It shifts that obligation of the landlord having to send to you a renewal notice to the tenant, who has to notify the landlord if they're not going to renew. Because if they don't renew, it's if they don't renew, it's up to the tenant to notify the landlord. Otherwise, it automatically renews for the same amount of time that the lease was written for. How much notice is required? There you go. So, notice required to terminate. Instead of saying all that, I'm just going to say notice required to terminate a periodic estate. You'll need to know this stuff for exams. Week to week, 1 week's notice. Month to month, 1 month's notice. Period of years, 3 months notice. Remember, if anybody terminates before the end of the term, they're in breach of contract. You're contractually obligated to be there for the term. but you do need to notify the other party if you're not going to be renewing that estate or not. So highlight under periodic estate the title and the first line that says a periodic estate, sometimes called period to period. I want you to write next to the title, instead of expiration date, has a renewal date in it. Once again, payments are due at specific terms, you know, first of the month. None of that stuff is different. The only thing that's different is in here is, do you got to sign a new lease at the end of the term, or does it automatically renew? In a periodic estate, automatically renews. And then I want you, in the first paragraph under periodic estate, highlight the last sentence that says the agreement automatically renews for similar succeeding periods until one of the parties gives notice to terminate. All right. Now, if we go down to the next to last paragraph under periodic estate, it says a New Jersey tenant, a New Jersey tenant who remains in possession of a leased premises after giving their notice of their intention to quit the premises may be held liable for double the rent. So if you notify your landlord that you're going to be moving out, you're not renewing, but you don't move out, then the landlord can hold you liable for double the rent, because they may have already arranged for another tenant to come in there, and they would be in breach of that contract for that new tenant if they don't have the unit available for them when they contractually said that they were going to. So they could pass on some of those expenses by charging the tenant that's currently in there double the rent for every month that they said that they were going to get out. Makes sense why they would do that? All right. So
Yeah.
when the lease term is longer than 1 month, the landlord may commence proceedings to remove the tenant who has held over. They call them a holdover tenant. If a tenant says, if the tenant is supposed to be out, at the lease expires, or they said that they're going to move out and then they don't, we call that tenant a holdover tenant. All right. So that's some of the terminology. Let me see if I'm going to have that terminology here at the end. It'd be a good time to have it in there. I don't know why we didn't have that in there yet. Let's put that at the beginning of that lease stuff at the end of this chapter. Leases, estates, and land. 4 types of estates. All right, I'm going to add in here that a holdover tenant is a tenant who did not vacate the premises what am I doing? Premises. No, I'm spelling that wrong. There's an E in there somewhere. There we go. Premises. The tenant did not vacate the premises after their lease term has expired. Now, a landlord can decide, they could say that they're going to accept the holdover tenancy, and there's nothing wrong with that. Okay, there's nothing wrong with the landlord accepting a holdover tenancy. But a tenant who notifies the landlord that they're going to move out and then does not, there could be consequences for them there. What do we call them? A holdover tenant. So the landlord can accept that they're going to accept the holdover tenancy, or they could move to vacate to evict the tenant. Okay. So the landlord could either accept the holdover tenancy or evict the tenant. But that's what a holdover tenant is. Someone who is not left after their lease has expired. That's it. All right, next one is a lease tenancy at will. A tenancy at will is for an or estate at will or tenancy at will. Is for an indefinite period of time. There's no length of time specified in the lease. So it's not defined in the lease how long it is. No length of time specified in the lease. It's for an indefinite period. Either party must give 3 months notice to terminate this type of estate. And of course, it would be terminated by the death of either the landlord or the tenant. We're going to add another thing in there. This would be kind of, when would this be used? Let's see, it could be used, so if the landlord was notified that the state's going to be taking their property by eminent domain, they're going to give the landlord notice, because the landlord, it's up to the landlord's responsibility to deliver that property vacant to the state. So how much notice does the landlord have to give the tenant?
3 months.
3 months. But if the landlord is notified that the state's going to be taking the property by eminent domain, they may not know when that's going to actually occur. So what is the landlord stuck there with a property that they can't rent out? No, they can rent it out to a tenant as long as the tenant agrees. I'm going to give you a lease for an indefinite period of time. We're not specifying how long the lease term is. But if you want to leave early, or if I kick you out, either one of us got to give each other 3 months notice to terminate.
Gotcha.
Okay. So an example when this is used. So I'm just going to write example when it could be used. I mean, it could be used anytime, actually. Example when it is used, I'll say. And they don't know, and the landlord doesn't know how long they can lease for, so they don't specify in the lease. But either party has to give 3 months notice to terminate this type of estate. up with that? All right. A tenancy at sufferance. What is a tenancy at sufferance? Well, a tenancy at sufferance is a situation that occurs at, or an estate, I'm going to put here, estate/tenancy at sufferance, is when a tenant had a valid lease. This is not for a squatter. A tenant had a valid lease at one point in time, but that lease had expired and was not renewed. And the tenant did not move out. So the tenant holds possession without consent of the landlord. They're now a holdover tenant. So tenant did not move out. And holds possession without without consent of the landlord. They're now a holdover tenant. They could be evicted at any time for non-payment of rent. First of all, they don't have a lease. They don't belong there. Second of all, they're not paying rent. You definitely don't belong there. But still, they have rights. That's why they do have an estate, because an estate defines the amount and kind of interest that one has in real property. Now, a holdover tenant, that's a tenant at sufferance, they could be evicted at any time, but they still have rights. A landlord cannot just drag somebody out by their hair and throw them out on the street. They cannot throw their belongings out there. They cannot change the locks on them. They cannot shut off services that may have been previously included in the rent, like heat and hot water and such. They cannot just do those things. They have to get the person out legally, because people have rights. And the process of legally removing a tenant from your property is called eviction. That's what eviction is. It's the legal process of removing a tenant. Okay. Here, we could even add that. We could even add that into this slide. Eviction is the legal process of removing a tenant. Is the legal process of removing a tenant. Okay. But it's going through the courts. It's going through the court systems. We're going to go over processes of who could be evicted and all that stuff. But so we got a tenancy at sufferance. Let's see, this one is number 3. This one was number 4. All right, so the tenant can be evicted at any time because they're not paying the rent. And just as fee simple absolute is the highest estate in land, tenancy at sufferance is the lowest. Because what is fee simple absolute? It is unrestricted ownership forever. It's the highest form of ownership recognized by law. So that's the person with the most interest in real estate, is somebody who has a fee simple absolute estate. A tenant at sufferance is the lowest estate in land. You're a tenant who's leasing someone else's property. Your lease expired, so you no longer have a legal right to be there, and you're not even paying them rent. You have the least amount of rights in the property, right? So that's what they mean by this last statement. Just as fee simple absolute is the highest estate in land, tenancy at sufferance is the lowest. The tenant's rights have expired and isn't paying rent. They, however, must be evicted through the court system because the tenant still has rights. And they all think that they know them.
That used to be a real big major problem going back, but nowadays it's like, you know, landlords are requesting previous address. You know,
it's still kind of tough. Well, landlords should treat it like a business. If you're going to be a landlord, you need to treat it like a business. Before you let anybody occupy your space, you should verify, just like they do with businesses. you should verify, first of all, their credit worthiness, their rental history. If they don't have a rental history, do you want to rent to them?
No.
There's landlord should treat it like a business. Okay, if a tenant,
Absolutely.
do a search, see if they've ever been involved in eviction proceedings. That's part of public record, right? If there was a court case filed, it's going to be in the public records. The landlord can pay a fee to do a search for that. Actually, they could pass it on to any prospective tenant. You can put that in
You
your
basically answered my next question, because my next question was going to be when a landlord is doing a research on a possible tenant, can the previous landlord come out and tell the new landlord, it took me X amount of month to get them evicted because they were not paying rent, they damaged it?
You got to be careful when talking with other people about something.
Yeah, that's what I was.
It could be considered slander, and all kinds of crap like that can come out of it. So you got to be careful what you say to people and how you say it. You could be a little bit crafty with your words, and then how you say it in a conversation if you're a landlord, to try to avoid any lawsuits. That this person said anything specific. I mean, were they a bad tenant? I rather really not comment. I mean, what do you get out of that?
Yeah.
Well, they certainly weren't a good one.
Would you rent it to them again?
Would you
I'd
say,
rather not say.
Were they a good tenant? I wouldn't exactly say that. I didn't say you were a bad tenant, but I didn't say that they were a good one either, right?
Yeah.
I mean,
gotta read between the lines.
Yeah. To try to, for a land.
Plus, if they were evicted out, like you said, there will be records.
There would be court records. You could find out if they were evicted. They had to go through the court system. Unfortunately, it's much harder to report them to credit reporting agencies as an individual landlord. If you're in a business and you have, if you're a property management company, or you have an apartment complex, you're a professional landlord, basically, meaning you don't just have one or two units. You have a couple hundred units, for like apartment complexes. Credit reporting agencies allow them to report to the credit reporting agencies the delinquent tenants who are late on their rent. They're allowed to report those, but unfortunately, they're not making that eligible for single renters, single landlords, because I guess sometimes disputes come up and people get emotional, and they're just like, what, I'm gonna F up your credit, and they don't want that being in there. They want it to be a business decision, so they don't want to deal with people like that are not professionals in the business, professional landlords. So they don't allow them to report directly to credit reporting agencies. However, if you do go to evict a tenant, that legal action is going to be in the public record that any future landlord can check. And you could search their name. You say, oh, they had to get evicted. Then you could ask that tenant, hey, what was this about? Or you could just add it into their scoring system. I don't like to just run credits and deny tenants because of their credit score, because we have the Equal Credit Opportunity Act that we need to follow in federal law that says if you ever deny somebody because of their credit, whether you deny them financing or anything because of their credit, you have to notify them in writing within 30 days with a reason, an explanation why they were denied. And in addition to explaining to them why they were denied, you also need to give them a free copy and access to their credit report that you got to pay for. So instead of doing that, I don't deny people for their credit. If their credit is banged up, I bet you their debt to income ratio and other factors are as well. So you don't have to deny them for their credit. And a landlord should also interview their tenants, not just look at what's on the paper. They should also interview them.
Yeah.
Now, don't ever deny a tenant because of any of the protected class reasons. Don't discriminate against people. But you have the right to interview your tenant. And if the tenant seems like they're going to be trouble to you, I mean, right off the bat, they're a wise ass. They're they seem like that they're going to be trouble to you. A landlord can pick and choose which tenant that they want to decide that they want to rent to. You have that right,
Right.
as long as you're not denying them for discriminatory reasons, for any of the protected class reasons, right? You do have the right to interview with a tenant, and if the tenant seems like, you know, they're not a good fit, you don't want this person in your house, you don't need to rent to them, okay? As long as you're not discriminating against them. Let me be perfectly clear about that. You cannot discriminate. But there are tenant scoring or grading systems that I prefer to use instead of just credit reports, where basically some of the major credit reporting agencies have put things in place like they call them tenant scoring systems, where you could actually, a landlord can log in, they could create a profile for themselves, and they could create a profile for each of their properties. So if you have several properties, for example, or if you just have one property, landlord creates a profile for themselves. They create a profile for their property, and then they have a link where they could create the questions that need to be what's important to them. They credit score, criminal history check, sex offender list check, eviction history check, state or national, all of these things. And you could put how much weight you want to place into each one of those things: debt to income ratio, active current employment check, or if it's not employment, source of lawful income. Because a person doesn't necessarily have to work. You can't turn them down because they don't work if they're getting a source of lawful income to help pay for their rent from other ways, other means, if it's lawful. For instance, if they're collecting Section 8 rental subsidy benefits, you cannot deny them because of where they're getting their money from. But you could add into the tenant scoring system, the grading system, all of these factors, how much weight you put into each one, and then if they're, give them a letter grade. Basically, you're scoring the tenant based on all these factors and not just one. So you're not just denying them because of their credit. So it's a neat tool that landlords can put in place there. And the best part about it is the landlord doesn't have to touch any of the tenant's information. They just send the prospective tenant a link. The tenant fills out, creates a login for themselves. Tenant pays themselves for the background check and the tenant scoring and grading that the credit reporting agency will do. And then they send a report to the landlord with a grade. You know, is this an A plus, A minus, B plus, B minus, all the way down to F tenant, and whether what tenants with what's the minimum grade that you were still willing to rent to the tenant. Okay, so the landlords can put together all those factors like that, and it's called a tenant scoring system. I have tons and tons and tons of links on this because there's a lot of different places that may offer that. But I prefer that instead of trying to chase around, get approvals to run credit, and you got to get that in writing, and that's a whole hassle. All right. So, what are the four leasehold estates?
Estate for years.
Estate
Periodic estate.
Periodic.
State at will.
At will. And then
State of sufferance.
Okay. So under tenancy at will, we haven't highlighted. Let's highlight now the first sentence, and then underline the words indefinite period in that first sentence that says an estate at will, an estate that gives a tenant the right to possess with the consent of the landlord for an indefinite period of time is a tenancy at will, and underline the term indefinite period. Okay. So which one?
That's under tenancy at sufferance?
Tenancy at will.
At will.
Oh.
Tenancy at will is indefinite period of time. Tenancy at sufferance is a tenant who had a valid lease, but it expired. They didn't move out. All right. And then in the second paragraph under tenancy at will, highlight the last sentence that says the term of an estate at will is indefinite, but the estate may be terminated by giving 3 months notice. Or it's next to last sentence under tenancy at will. The term of an estate at will is indefinite, but the estate may be terminated by giving 3 months notice. And then tenancy at sufferance, pretty much highlight the whole paragraph. You know, a tenant at sufferance can be is a tenant who lawfully came into possession. Basically, they had a valid lease at one period of time. Lease expired, they didn't move out. They're now a holdover tenant, but they're a holdover tenant who's not even paying rent. So they could be evicted at any time. And then with your pen, underline that paragraph to separate it from the next sentence, which I'm also going to have you highlight, but it's a separate issue altogether, where it says just as fee simple absolutes the highest estate in land, tenancy at sufferance is the lowest.
Can you repeat that one more time, Victor?
Yep. Basically, you highlighted everything under tenancy at sufferance, but separating the paragraph from the next sentence, just as fee simple absolutes the highest estate in land, you're going to draw a line separating those two statements because they are two different statements.
Okay, thank you very much.
So you need to know those 4 leasehold estates, just like you need to know the 3 freehold estates. What are the 3 freehold estates? You got one of them right here, fee simple absolute.
Fee simple absolute.
Estate for years.
Estate.
Well, hold on a second. Freehold estates. What are the 3 types of freehold estates? We have fee simple absolute, also known as fee simple or fee simple absolute. It's the highest estate in land. It's unrestricted ownership forever. What do we call ownership forever based on a restriction?
Tenancy at will.
No, that's a leasehold estate. Talking about freehold. Freehold is ownership. Well, what are the 3 freehold estates? Fee simple absolute, fee determinable, also known as a defeasible fee, and a life estate. Remember those 3 from way back when? Okay.
What chapter was that?
That was chapter. It was either chapter 6 or 7. I believe it was. I believe it was chapter 6. Chapter 6. So those are all the estates. You know, so it's good to organize your notes by putting all the leasehold estates together. Have the list of freehold. What does freehold mean? It's the category of ownership. There's 3 freehold estates. There's fee simple, fee determinable, and life estate. And then there's 4 leasehold estates. That's less than freehold. You're not able to hold. You're not free to hold the property forever or a lifetime. It's for a limited period of time as defined in a lease. And a lease is intangible asset considered personal property, whereas a freehold estate is considered to be real estate because you own the real estate. So there are 4 types of leasehold estates. There's estate for years, periodic estate, tenancy at will, and tenancy at sufferance. Why do they call it an estate or tenancy at sufferance? Because you're a tenant whose lease had expired, you did not move out, and you're not paying rent. Every day that you stay there, you cause the landlord to suffer. Thus, a tenancy at sufferance. Make sense? Awesome. So here's just a recap of the 4 types of leasehold estates. Estate for years, it's for a specific period of time with a definite termination date. Does not have to be for a period of years, can be month to month or day to day. Periodic estate is from period to period with no specific termination date. It is perpetual, no specific termination date because it has a renewal date in it.
So the leasehold estates are basically tenants. The freehold estates are owners.
Yes.
Yes.
Okay.
All right. A tenancy at will is for an indefinite period of time, no termination date, with consent of the landlord or by a court, and can terminate by the death of either the landlord or the tenant. and requires 3 months notice to terminate. This is basically a good little rundown of the basic core elements of what each one of these estates are. This is a good slide to study from. And a tenancy at sufferance is a tenant who lawfully came into possession of the leased premises. However, their leasehold has expired and they did not move out and they are not paying rent. Tenant at sufferance can be evicted at any time.
Okay. So you're adding this to the document, to the
Well,
shared
yeah,
doc.
yeah. Well, this is part of the slideshow here, but this is a good slide to study from the 4 types of leasehold estates. It's basically a recap here. This recap will look. I even have on here what demise means is a transfer of property by lease. Leasehold estate is a tenant's right to occupy someone else's land.
Right. Holdover. A
A
tenant.
holdover tenant is a tenant whose interest in land expired,
But does not.
but does not vacate at the end of the lease term. How about
So
that?
they're considered the tenancy is sufferance, the holdover.
Only if they're
Not
not
if they're
only
paying.
if they're not paying rent.
Okay. So holdover tenants are paying rent.
Well, no, a holdover tenant, in its strictest definition, is a tenant whose interest in the land, in the real estate, expired, but did not vacate. Did not vacate at the end of the lease term. That's it. Remember, landlords can accept a holdover tenant or they can reject them. If they reject them, they could evict them. Or they could just accept tenant. They don't have to have a lease with you, ongoing lease. They can accept that. Now, if a landlord, if your lease expired and you didn't move out, but you keep paying the landlord, the action of the landlord accepting the tenant from the payment, what kind of contract does that create?
The periodic.
What kind of contract does it create?
Oh, I'm shaky on the contracts.
It creates an implied contract.
Implied.
It's an implied contract. It's one that's expressed by your actions rather than your words. So
Right.
a holdover tenant is one whose lease had expired, but they didn't move out. But the action of them paying the landlord still, and the landlord accepting the check. And if they cash that check, it creates an implied contract because there's nothing in writing, but it's assumed that they're okay with you remaining there as a tenant.
Right.
They accepted your payment still. If they wanted you out, they would have evicted you, right?
Yeah.
So that's why it creates what's called an implied contract. So a holdover tenant is not good or bad. It just means that the tenant didn't sign a new lease and they didn't move out.
Right. Okay.
Okay. A lot of good stuff here in this one slide to study from, basically for everything that we've gone over so far. Other than that, a leasehold estate is a tenant's right to occupy someone else's land, personal property.
Don't do that.
It's considered personal property and an intangible asset. Try to shrink this down a little bit so that we can scoot it up a little bit here. I thought I had these slides all perfectly made up already, but look at that. You can always tweak them a little bit, I guess. So there we go. Save the changes and next slide. Okay, so we're going to go over some of the standard provisions in the lease. You see that this matches up with what we see in the book now too. It's just like any contract. In order for a contract to be valid, you got to have competent parties, right? So they have to have capacity to the contract. So that means they're competent parties, right? A demising clause where the landlord lets the premises and the lessees to take take possession, takes possession. There has to be a description of the premises in the lease. These are standard provisions of any lease here. There has to be a clear statement as to the term. So the term of the lease has to be stated. So the term is the duration, okay, of the lease. If you're gonna put a term in the lease, you have to specify what the start date is and what the end date is, or the renewal date, unless it's a tenancy at will, but then that needs to be specified in there as well. It's for an indefinite period. Specification of the rent, you have to specify how the rent is going to be paid. Or specifics of rent and how and when it will be paid. Yeah, so specifics of rent. How much is it? How much is the rent? How and when it's to be paid. If not stated in a lease, New Jersey law says that rent is due in the arrears. The arrears, this term right here, let me bolden that. You need to know that. It means after the end of a period which something is due. Or after the end of a period. Let's leave it at that. The arrears, your rear is your behind, right? So there we go. Your rear is behind you. So it's in the end. Your rear is also sometimes called the end. So arrears is at the end of a period, after you've used it. So if a landlord does not state that rent is due on the first of the month, if it's not specified in the lease, New Jersey law says rent has to be paid at the end of the month, not the beginning. Leases must be in writing if for a term of more than 3 years. Now, keep in mind, if licensees are involved, doesn't matter how long the lease is. It could be a 1 week lease. We need to get it in writing. This is just general contract law in New Jersey. So I stated that here. If an agent isn't used because we follow licensing law, which requires all contracts be in writing. All right. And signatures. Now, a lease must be in writing for a term more than 3 years, and can be recorded if more than 2. And signatures. Any contract, in order to be valid, must be signed by all parties, right? And that's basically everything that was in this list here. Here's some of the typical provisions of the lease: use of the premises. If you don't specify in the lease what a tenant can use it for, they could use it for any legal purpose. Use of premises has to be specified in the lease. So this more applies to commercial real estate than it does to residential. How I'm phrasing this here. All right. Because a residential property, you could only use it as a residential property. You can't start a commercial business in the middle of a residential unless it's zoned for it, right? Residential area unless it's zoned for it. The term of the lease, start and end / renewal date. New Jersey requirements that identify business relationships have to be specified in there. You know, how are we working with them? Buyer's agent only, or landlord, tenant, or transaction broker, right? Has to be specified. And here, look, I just gave you the example, page 168. So where it says New Jersey requirements in the book,
Yes, yes.
just write this next to it, page 168, line 305, or section 39. And highlight the first sentence there. All offers, contracts, or leases prepared by licensees must indicate the business relationship the party has with respect to the parties named in the document.
We're on page 168.
Section 39, line 305. You see it says here? Page 168, section 39, line 305.
Thank you.
And then you said under New Jersey requirement, highlight the first sentence.
Yep, and highlight the first sentence there. It basically says that you have to disclose your agency relationships. You got to do it in every document that we give to people. We disclose our agency relationship. The only document that it doesn't have that checkbox on there that says I represent this person as a buyer's agent, seller's agent, disclosed dual agent, or transaction broker. The only document that we have that doesn't say that is the lead paint addendum. I want to see if I when I was there before, if I printed out a blank lease. You know, I got the sales contract, but listing. And I'm just going to show you really quick because, or you could go to page 168 and you can look at section 39, line 305, while I download really quick that's you know, the lease. To show you guys on the lease on the screen, you guys can look at it in the book right now. And on page 168, section 39, line 305, that you see the check boxes, or it says, you know, how you're representing somebody or how you're working with somebody. I'm right now, I'm just downloading the latest lease. So, and I'm going to open it up on screen right now. After I mute everybody there. Okay, I got the lease opening up. I'm going to show you guys on screen. Once it opens, come on. I got to get a supercomputer for this stuff, having all these windows open. Oh, there it is. It already is open. All right, so here's the lease. Where is it? Section 39, line number 305. So you see we got the line numbers here on the sides of the page. This is very helpful. It's on all of our contracts. The reason being is you look at the last line on the page, it's 38. What should the next page begin with? The
39.
next should begin with 39. If there's a gap there, you need to contact the other person who sent you the contract, tell them that it's incomplete, that it was cut off when they scanned it or faxed it. So on line number 305, we got some scrolling to do. 305. Well, actually, it looks like the lease I downloaded has some changes to the one that's in the book. It's still section 39, but it actually begins here on line number 317. You see over here, it says declaration of licensee's business relationship on the screen here.
Yeah.
And then you got to check off, you're the landlord's agent, tenant agent, disclose dual agent or transaction broker. All parties have to disclose. This is what it looks like when you're disclosing who you're representing. This is section 39 here. This is showing all of that. This is what we refer to as the disclosure of agency relationships. Okay? That's what it looks like. Just want to make sure that you guys know. All right.
Okay.
And then the lease itself also has to have in there an acknowledgement that the CIS has been provided prior to first showing. Because when do you need to provide the CIS? What is the CIS?
The consumer information statement.
And what does it do?
You have to give them the first thing you give to them.
It is the first document that you give to anybody, but before
that you intend to do business with.
But what does it do?
It's a disclosure of
On the
agency
agency relationship.
explaining how your agency can work with them and how your
Or
agency will be
That's it. So
representing
it's a
them.
disclosure of agency relationships. I heard somebody say that in a compacted way, and that's correct. It's a disclosure of agency relationships. That's the way they're going to refer to it on exams. So a CIS is that consumer information statement, it's a disclosure of agency relationships. It has to be given prior to the first showing. We're talking about their finances or motivations, right? Just going to skip over the lease here. Actually, I'm not going to skip over the whole lease. As far as in the book, you see this slide is talking about window guards, and in the book, the version of the lease that's in the book is on page 168. It's section 36, however. I'm going to delete this line number here because that's going to change too. Okay. Window guards. If you go to page 168 in the book, section 36 in the lease, I want you to put a highlighted box around the entire thing, but I'm going to have you only highlight certain things on the book. You need to know you will get questions about window guards on state exam.
What page is that again?
Page 168. You see right here on the slide, it says 168, section 36.
Yeah.
It's at the top of the page.
Okay.
And let me see. I got that lease opened already. Let me see if they got the disclosure about window guards. Section, what did I say? 36. Let me back it up a little bit. You see right here, we got it on screen here in front of us too. Window guard notifications.
Hello, can I place an order? What would you like? Can I have a large?
All right. So what I want you to highlight, see this, it says all this. I want you to put a highlighted box around this section 36 that says this. We're going to read it, and I'm going to tell you exactly what to highlight in here, though. Well, first of all, highlight the title, Window Guard Notification. And you may even write it big on page, in the book at the top of the page, write window guards and underline it with your pen so that it stands out. You need to study window guards. What are window guards? Well, the owner, the landlord, is required by law to provide, install, and maintain window guards in the apartment if a child or children under the age of 10 years or younger is or will be living in the apartment or is or will be regularly present there for a substantial period of time. If the landlord gives the if the tenant gives the landlord, the owner, a written request that window guards be installed. Huh. So when do window guards got to be installed?
When
If
the tenant requests it,
if the
gives a
tenant
written request.
requests it, if there is a children there are children living there 10 years of age or younger, or will be regularly present there. So I want you guys to highlight this. It's the second sentence under window guards in the book. See, the lease in the book is a little bit different than this than the window guard notification that you're seeing here on screen, which is the latest one, which I just which you're seeing on screen right now.
So basically, we're gonna highlight what you have highlighted on the screen.
Correct, which is basically the second sentence in on the lease that's in the book under window guards.
Okay.
And then let me continue reading. The owner, the landlord, is also required upon the written request of the tenant to provide, install, and maintain window guards in the hallways to which the person or tenant unit have access to. Okay, so if it's in a 1, 2, 3, 4 family house, the owner is required to install window guards in the hallway windows at the tenant's request as well. However, if it is in a condo complex, then the HOA, the homeowners association, is responsible for installing and maintaining the window guards there. Okay. That's what they're talking about here. If the building is condominium or cooperative, then they're responsible for maintaining the window guards. I want you to highlight window guards are only required to be provided on first floor windows where the window sill is more than 6 feet above grade, that's above the ground level, or where there are other hazards that make installation of window guards necessary to protect the safety of children. Now, the reason why they don't require them on higher up levels is because a lot of buildings on higher up levels may have fire escapes. If you put window guards prevent the window from opening. They only allow the window to open a little bit, not enough so that the child can crawl and fall out and hurt themselves. Okay, so that's window guards. Let's take a picture. Let's take a look. Here are some examples of window guards that you guys see. Well, these bars, I guess bars can be considered window guards, but if you're using bars, they have to be so close together. But window guards usually prevent the child from falling out, because we've seen window guards like this one right here, where children have slipped right through them and they fell out of the window. So
we have that in my country everywhere to prevent thief coming inside the house.
Yeah, to prevent thieves. Yeah, you got them in bad neighborhoods too, right? But
Florida, Miami has that a lot.
Yeah, but this is really to try to not talking about for security purposes, the bars over the window, but more for child safety. Now, window guards for child safety would actually prevent the window from opening up. Let me see. Well, this is New York's window guards example. They would actually prevent the window from opening up enough so that the child can get out of it to begin with. If I can find some more information about this for New Jersey window guards, I'll look up, see if I can get a video or something to show you guys about it. But, you know, if you got some of the plastic windows, even that these newer windows that they make up, they got these window guards on them where these plastic tabs come out. So you could only open the window maybe about, you know, a couple of inches, you know, where no child is going to get through that. You see, here's another example of a window guard for windows that swing out. You see this one? It only allows the window to open a couple of inches. That's not enough room for a child to push through and fall out of the window. Okay, so window guards can be bars. They can be stoppers like this that could prevent a window from swinging open or sliding open too far. Okay. All right, you do get questions on exams on this. Okay, so when are window guards required? If there's going to be a child or children there 10 years of age or older, living or regularly present there. If the window sill is, if the sill is more than 6 feet above grade, and the tenant gives a request, written request to the landlord that they be installed. You'll need to know that for exam. That's why I put it here on the slide. I made a slide about this. So they must be installed by the landlord. If a child 10 years of age or younger will be living there or regularly present. If the tenant gives landlord written request to install window guards, HOAs are responsible for installing window guards in hallways and common areas, and only required on first floor units if the window sill is at least 6 feet above grade. So this slide is good to study from. Leases also have other provisions in leases. They have to state that the federal lead paint disclosure, yes, even on leases. We got to give that lead paint disclosure, not just the purchasers, but any contract where we're for residential property, we need to give that federal lead paint disclosure. When the property is built prior to 1978, we also got to give the tenant the pamphlet, protect your family from lead in the home, right? Let me see if I got a link there for the lead pamphlet. I don't. So let me get you guys a link for that, for the lead paint disclosure. So we can look that up really quick. Lead paint disclosure or pamphlet in New Jersey can probably be found on the, I mean, you could get it from the EPA's website, but it could also be found in New Jersey's tenant regulations for lead safe homes, perhaps. The Department of Community Affairs website in New Jersey would also have the information on lead hazards and lead information, lead abatement, and the brochure. So I'm going to make all of these links, which I know I'm not showing them on screen right now, but I'm going to make all of these links available to you here for pertaining to lead hazard pamphlet and disclosures. So we're going to make that available to you through that. I'm going to copy it and I'm going to paste it in that tenant rights thing. This is the lead pamphlet right here, by the way. Protect your family from lead in the home. Okay. It may have different covers, but it's usually a blue and orange booklet like this. It basically explains to people the dangers of lead, where it's found, what to do if you have lead in the home, you know, its effects on the human body. It's basically an educational pamphlet that we need to give to buyers and tenants. Explains them their rights, safety line, health lines, resources are all available to people there. So this is the 2020 latest booklet about it. I'm going to copy that link and I'm going to post that in our class links folder there, or class links file. I'll also make it available right here on this slide. So let's go back to the slideshow. It's a long link though. There we go. But you could also get it from the New Jersey Department of Community Affairs website. They have a page for all of that as well, pertaining to lead hazards in the home. All right, so I did a little bit of an update. I went back and did a little bit of an update to the window guard slide as I was researching some images and the documents that I have that I was giving links to. And I came across some additional interesting information, so I updated the slide with it. Not that you need to know it for exam, but I found out that buildings with 3 or more units, landlords must install window guards unless the tenant tells them specifically that they don't want them. And they have to check with them every year to see if they want them by February 15th. And they have to fill out a form about window guards every year if it's buildings with 3 or more units. And
that law is right here in Jersey, correct? That's pertaining to the laws here in Jersey?
Yes. And they need to inspect those window guards regularly throughout the year. And if you have an air conditioning unit that's a window unit, what about that? Well, they must use tamper-resistant one-way screws to bolt the AC unit into the frame. This way, somebody can't just back them out with a regular screwdriver. And they cannot leave any spaces greater than 4.5 inches where a child can slip through. And that residents may be charged up to $20 for window guards installation requests. Just some interesting info, but what do you need to know for exams? They must be installed at the tenant's request on first floor units if it's 6 feet above grade or greater. Okay, that's all you need to know for exams.
Okay.
All right. So that was the window guard thing. Typical lease provisions also include the federal lead-based paint hazard disclosure if the property was built prior to 1978, right? Late payments. I thought I had something in here. I may have deleted it by mistake. So late payments for rent. You know, tenants, not all tenants can be charged late fees for rent. So tenants can be charged if they're late for rent. However, there is an exception to that. You know what? Security deposits should be before that. Oh, that's why. Late payment for rent. I got it on a different slide. So let me just delete that from here, this slide. So let's go over security deposits first. Security deposits for, at least for residential real estate. What's the purpose of a security deposit? It's to reimburse for damages or to cover any damages done by the tenant, not for normal wear and tear. So it's a guarantee of rent payment and for damages. It must be placed in a special interest-bearing account by the landlord. Used solely for security deposits. A landlord can't just put the tenant's security deposit in their own checking or savings account. They have to put it in an interest-bearing account that's used only for security deposits, because the tenant must be notified where that money's being held, and the tenant must get the interest earned. So tenant must be paid the interest earned or credited to them on the anniversary of the lease. Penalty is that the landlord would be required to pay double the entire security deposit to the tenant if they don't do this. But the tenant would have to know their rights, and they would have to bring it up and take the landlord to court. Okay, but the tenant must get their interest. Tenant must get their interest. Because otherwise they could have kept that money in their own bank account and earned interest on it. So any long-term held money like that has to be in an interest-bearing account. Tenant has to get their money for it. Maximum security deposit allowed by law is 1.5 times the monthly rental figure. So maximum is 1.5 months rent as the security that can be charged by New Jersey law. There's no maximum set for commercial real estate. Pet security can be charged as long as the total security deposit does not exceed the 1.5 times month rent. So if you're already charging 1.5 times month rent, you can't charge additional pet security. And service animals can't be charged any additional fees. They must be returned, and the security deposits must be returned within 30 days after the lease termination.
You mean a landlord cannot charge extra fees if you wanted to have a pet, if pets were allowed inside the house?
No, they can for pet security, but not if they're already charging 1.5 months rent.
Yeah, that's what I'm saying. So if a landlord charged 1.5 months rent in the security,
they can't charge any additional. They can't charge any additional security. The maximum law. I mean, you're just making up something and calling it pet security. What is it still? It's still security. The law limits the amount of security that a landlord can charge the tenant to 1.5 times the monthly rental figure. Doesn't matter what what you call it. Okay. Now, if you wanted to, you could charge additional rent or a one-time non-refundable fee for having the pet.
Okay. They can't do that. They come out and say, if you want to, because I've seen that if you want a cat, it's this much extra per month. If you want to,
yeah,
if you're having a dog,
it's additional rent. You're paying rent for which is non-refundable, so it's not security.
Okay.
And you could charge also either a one-time monthly fee or additional rent or both. Just can't charge any additional security if it's going to exceed the 1.5 times the monthly rental figure. So what's the maximum? Maximum 1.5 times rent as security can be charged. Okay. If there are no damages, that money needs to be paid back to the tenant. Penalty for this violation is double the entire security deposit. Now, what if the tenant moved out and didn't tell you where they were moving to? Send it to their last known address, which would be the place you were renting to them. They may have forwarded their mail.
Yeah.
Okay. And then if they don't collect it, you get to keep it. Anybody know? Anybody got a guess? Well, I would say before you try to keep that, you consult your attorney.
Right.
They'll tell you to turn it over to the state, and it'll go to that fund where the tenant can claim their money, right? That missingmoney.com or the state's website. Okay. So any money that's deducted for damages requires itemization for deductions. So deductions for damages requires itemization. You got to give them an itemized list of the costs for the repairs and what you're charging them for the damages, so they know what's being held. You can't just say, I'm keeping all your security. Late payments can be charged to tenants, but you got to check your local rent control laws and ordinances. Now, tenants that cannot be charged late fees. So So any tenant that's receiving Social Security, old age railroad retirement pensions, or any government pension must be given a grace period of 5 days free from late fees and penalties. So let's highlight that. Well, first of all, under security deposits in the book, let's highlight the third sentence that says residential landlords may charge no more than 1.5 times monthly rental figure as the security deposit. That's the third sentence.
Third sentence.
Under security deposits.
The one that starts with the tenant is to be notified?
No, residential.
No, residential, I got it.
Yep.
Thank you.
You're welcome. And then in the next paragraph, the second sentence, the landlord must return security deposits minus itemized deductions for damages by the tenant within 30 days after the end of the lease. The penalty for violating this requirement is double the security deposit.
So it has to show that it was mailed out within the 30 days, not that you will receive it
Correct.
within the 30 days, but it has to show that it was mailed out within the 30 days.
Correct.
Gotcha.
The tenant is not entitled to apply the security deposit to the last month's rent, nor can the landlord keep the deposit if the only damage to the apartment is construed as normal wear and tear. Now, if you want to add provisions into the lease that would say that, well, consult with an attorney first about adding anything like that in there. Now, under late payments, the fourth line, it says landlords, or second sentence says landlords. We're going to highlight landlords may charge late fees for late payment of rent, except to senior citizens receiving Social Security. So basically anybody collecting Social Security. Old age railroad retirement pensions, or any other government pension must be given a 5-day grace period free from any late charges. All right. And I'm going to put a little notation here for you. Note, always check local rent control laws before.
Where would we obtain those rent control laws at? Would that be on the internet?
Each municipality, you got to check with each municipality. Not all municipalities have rent control rules, but those that do, you need to comply.
Gotcha.
So you need to check with each municipality that you're doing business in to see if they, first of all, even have rent control laws. And if they do, you need to comply with whatever they are. They may restrict how much you could charge in late fees and penalties, when you could evict tenants. Well, the eviction of tenants is pretty standard, but what you could charge late fees or penalties for, etc. You got to check and see how much you could raise the rent by, all that stuff. We'll be going over that in a little while. Legal principles of leases. Leases carry with them, let me see, legal principles of the leases. We're going to be talking about possession of the leased premises.
Yeah.
Improvements. Tenants cannot make improvements.
That's how I like it.
Hold on, let me mute that. Tenants cannot make improvements without the written permission of the landlord. And they can't even paint the apartment without the landlord's permission. Install ceiling fans, anything like that. So improvements, can a tenant make improvement? Well, not without the landlord's written permission. So I'm just going to say improvements require written permission from the landlord. Possession of the leased premises, tenant cannot take possession until the dates specified on the lease. You want to lose your license quick? Go ahead and give a tenant a key early so that they could start moving their stuff in. Okay. If they ever ask that, don't do that. Do not give a tenant permission to move into a property or drop any of their stuff off there until their lease is supposed to begin.
If you do, what would be the result of that?
You could lose your license for it. Put them in touch with the landlord. Let them have a conversation with the landlord. If the landlord wants to allow them to do it, that's on them. But don't you ever give any keys to somebody, allow them to move in or start doing improvements or moving their stuff there before that lease commences.
So that would be the discretion of the landlord if he wanted to do it.
Well, first of all, the landlord doesn't have the money yet. You may not have the permits yet because you didn't get the inspections yet. Nobody's supposed to be living there yet. You're violating the local laws. You're violating your real estate licensing law. You're not looking after your client's best interest. That person moves in there. Now they're not paying rent. Now the landlord's stuck with somebody in there that you invited in early.
Yeah.
Maintenance of the premises. Leases carry with them an implied warranty of habitability. Meaning that the premises are fit for human habitation. The tenant must return the property in the same condition as it was received, with allowances for normal wear and tear. Landlord is responsible for repairs unless specified otherwise in the lease. Department of Community Affairs inspects buildings with 3 or more units, not counting unit owner lives in, if they're living there. If rent is withheld by a tenant, it should be placed in an escrow account.
What would be the reason that would allow a tenant to hold the rent? What would give him the legal right to say, hey, I'm holding your rent in an escrow account? Could it be until these certain repairs come into play?
See the screen? For repairs landlord has not done, or to try to motivate the landlord to do repairs.
Gotcha. And of course, any interest that that rent has accumulated in escrow will have to be given to the landlord because that was his money in there, correct?
What are you talking about? No. We're talking
No,
about.
no, that's right. That's
Hold on
right.
a second.
Escrow, yeah.
We're not involved here. We're not involved.
Yeah.
We're talking about the tenant. When the tenant is renting from a landlord, we're no longer involved in that.
Yeah, yeah, no, I understand.
Property management company, but we usually introduce a tenant, landlord get the inspections, one gets the keys, one gets the money, we earn our commission, we're out of it. It's a landlord-tenant issue.
Right.
All right. So, but if rent is withheld by a tenant, for damage, because they want repairs done, it should be placed in an escrow account because they're going to have to pay that money to the landlord later.
Yeah.
A lot of tenants say, I know my rights. I don't got to pay rent until you fix it. And then the landlord fixes it, and then they think that they could just resume paying the rent from that date forward. No, you also have to pay all that back rent you've been withholding. You've been living there. You've had your crap sitting there. You got to pay rent.
Yep.
And that's when tenants end up getting evicted because they think they know their rights, but they don't. A little knowledge is a dangerous thing.
Yeah, oh yeah. That's a fact.
I know my rights. No, you don't. Apparently you're not. Apparently not. And that's how people get in trouble. They think they know their rights, and then they do the wrong thing. And then they think the system's corrupt, the system's screwed up. It's everybody else's fault but their own.
Is it illegal for a landlord to tell a tenant to the rent that, say for instance, the landlord needed to fix something or replace something, and the landlord said to the tenant, okay, the rent that you have for me for this month, you could go ahead and use that to fix what needed to be fixed?
Most landlords won't do that because they don't know what they're being charged.
I didn't really get that. Could you repeat that one more time?
Okay, I'm saying that, say for instance, there's something that needs to be fixed in the rental property. And you call your landlord and you said, listen, there's something that needs to be fixed there or replaced or whatever. And the landlord said to you, the landlord would say to you, okay, the rent that you have for me for this month, you can use that money to replace or fix whatever needs to be fixed in the property.
All right. New Jersey does recognize the tenant's rights to repair and deduct from the rent if the landlord gives them that permission. But they're going to have to make sure that if something that requires permits is done by a licensed person that require, and that the proper permits were obtained, and to make sure that things were done right. You don't just go and get the highest quote you can somewhere so that you can pay the landlord the least amount of money. You get your buddy to do it or you do it yourself, or the landlord can say, no, that's a no-go. It doesn't cost that much to get that done. You're insisting it does. And now you want to not pay them that money because you're claiming that that's how much it cost you. When it goes to court, the judge is going to ask, because it's a tenant's responsibility in that situation to try to lessen the costs to the landlord. So you should be shopping around, doing a little price shop and trying to get quotes from at least 3 different sources. And if those quotes are all expensive and high, courts are not stupid. They'll get their own quotes, and when they do, they'll for the averages on that, and they'll charge accordingly from that. So, but yes, New Jersey does recognize the right to repair and deduct. So let's see. So improvements require written permission from the landlord. Maintenance of the premises, leases carry that implied warranty of habitability. All right, we already went over that one. State inspection, often referred to as the green card inspection, is required for any buildings with 3+ units, not counting unit landlord lives in. The DCA does the inspection. That's the Department of Community Affairs performs the inspection on buildings with 3+ units. It must be done at least once every 5 years for buildings with 3+ units. Hotels must be inspected at least once every 3 years, and the inspection can be done without prior notice. The inspectors can just show up. We need to know this because when we're selling buildings with 3 or more units, we need to ask, did the owner obtain the green card yet? Now, that's not the official name of it. It's called a state inspection. But you guys need to know the industry lingo. The industry lingo, when you're actually out there working, it's referred to as a green card inspection. Because if somebody asks you if you got the green card yet, did you got the green card for the building? And you look at them like they got 3 heads, they're going to see you don't know what the hell you're doing. Okay? So a green card, when they talk about a green card, it's a state inspection. Why do they call it green card? Because when you pass the inspection, they give you a card that's a pass certificate, and it's green. Thus, green card. At least it used to be green. So it still keeps that name out there. Anybody that's been in there for a while knows it's called the green card. Okay? Okay, assignment transfers the entire lease. However, when you transfer a lease, does the owner give up their responsibility? I'm sorry.
No.
Sorry, not the owner, the leaseholder. So
No.
assignment transfers the entire lease. However, the lessee is not relieved of their obligation if they sublet and the new tenant is violating the lease terms. They could still be held liable. So if you're leasing a property, you assignment. First of all, you can't assign a lease. Requires the landlord's permission. First of all, requires also transfers the entire lease. If landlord permits it.
That's mostly in commercials. I don't know if they do that in.
It could be residential
estate.
too, but usually in residential,
Yeah.
and even in commercial, there's usually provisions in the lease that the lease is
In Amboy, everybody's a police all the time.
that you can't assign it, not without the landlord's permission. But the landlord could always allow it. Okay, so the lessee transfers the entire lease if landlord permits it. I'm going to just say the tenant. The tenant is not relieved of their obligations if they sublet and the new tenant is violating the lease terms. So that's basically subleasing. Transfers only some of the lease. Well, assignment, that would only transfer the entire lease in the event of novation, right? And if the landlord permits it. Subleasing transfers. It still transfers the lease, but it never really. So it transfers the lease. If the landlord permits it. Subleasing transfers the lease. Once again, if the landlord permits it. Assignment is basically transferring of one person's obligations to another. When you're doing it, when it's a lease, you're subleasing, you're transferring your obligations to someone else. Subleasing transfers the lease if the landlord permits it. And the destruction of the premises, tenant is responsible for damages. Termination of lease. All right, so heating of the rental units. Let's see. Let's do some highlighting in the book. Under improvements, go down to the fourth line and highlight this in the sentence that begins with the word however. I start highlighting a couple words over where it says the tenant may be given the right to install trade or chattel fixtures by the terms of the lease. It's customary to provide that such fixtures may be removed by the tenant before the end of the lease term. What is a trade fixture?
Like a light, a ceiling fan?
Not an example. Not an example. Describe to me what a trade fixture is.
Oh, okay.
It's anything that is placed in the property for the tenant's use for service, like for a salon or
for business, yes. So trade fixture is considered personal property. That it's a trade fixture is personal property. It's a fixture that's used for business purposes. All right. Let's see, I got something in here about that. We're on slide 19. Let me see. Trade fixture. Just look up fixture. I know I got the term fixture somewhere in this. Hmm. Well, we're going to add it in here. Trade fixture. Thought I had a whole slide on this. Actually, you know what? I do have a slide somewhere. Give me 1 second. Maybe I just need to copy them into here.
Yeah, it's in the I think it's on the third channel,
I know I got them in a different chapter, but I have them also in a different folder here. Some things that I need to combine still. All right. Nope, guess not. I have a different slideshow open that I was just searching for that. Yeah, it's also in chapter 3. So let me go there. I'm gonna go to chapter 3's slide, and I'm gonna go borrow that slide from there, from trade fixture. Yeah, I know it's in here. Why is it not finding it? Oh, wait, it wasn't in chapter 3. Trade fixture was chapter 5, I believe. There we go. So a trade fixture is considered personal property installed and used for business purposes by a tenant and can be removed before the lease expires. Otherwise, it becomes a fixture and part of the real estate. And some of the examples there they give are the barber's chair, the pumps at a gas station, shelving in a supermarket, the sinks in a beauty salon. I don't know why this text is so close to each other. We got to give it a little more space. Hold on. That's too much. Anyway, where do you remove the formatting? Format. Remove formatting. Where the heck is that thing? Clear all formatting. There we go. Boom. Okay. Nope, it's still formatted. Whatever. So trade fixture here. Let's just retype everything that's there in that one. Trade fixture is considered personal property. It is a fixture. Let's do this a different way. Trade fixture is considered personal property or is used in a business, is a fixture used in a business for business purposes. And is considered personal property. Tenant can remove it before the lease expires. It is possible for a trade fixture to become a fixture, part of the real estate, if they don't remove it before the lease expires. And then some examples of the trade fixtures are, let's see, some examples would be the barber chair, barber's chair, gas station pumps, sinks in a beauty salon, shelving in a store, etc. The ovens in a restaurant, right, et cetera, et cetera, et cetera. So, is it possible for an item that is a trade fixture to become a fixture?
Yes.
Sure. So a trade fixture is a fixture used in the course of a business, used for business purposes. It's considered to be personal property. The tenant can remove it before the lease expires. It is possible for a trade fixture to become a fixture, part of the real estate, if they don't remove it before the lease expires. Examples are barber's chair, gas station pumps, sinks, shelving in a store, ovens, hoods and ovens. You know what? I don't want to start getting into all those. Okay, so etc. It's good enough. Let's see. Heating and rental units. When heat is included in the rent, between October 1 and May 1, it must be heated. The heat must be set, must be at least 68 degrees between 6 a.m. to 11 p.m. and at least 65 degrees at night. This is when heat is included in the rent. So let's go to under maintenance of the premises. In the second paragraph, second sentence, we're going to highlight the Department of Community Affairs inspects buildings with green card, with 3 or more apartments, at least every 5 years for compliance with building and construction standards. And at the end of the line, we're going to write green card.
What page is that? Excuse me.
That's under maintenance of the premises on page 171. The Department of Community Affairs is the second paragraph under maintenance of premises. The Department of
Gotcha.
Community Affairs inspects buildings.
I don't see, I'm sorry. I have after assignment and subleasing destruction of premises.
No,
and then,
you're ahead of that. That's after maintenance of premises.
oh, okay. I see it
So
now.
the second
Sorry.
paragraph under maintenance of premises, the second sentence. The Department of Community Affairs inspects buildings with 3 or more apartments at least every 5 years for compliance with building and construction standards. And we're gonna write at the end of that line, green card, because they refer to that as the green card inspection, right?
Yes, sir.
Now, it does say in there, if the landlord fails to make repairs, New Jersey does recognize the tenant's right to repair and deduct, or the tenant may withhold the rent until the repairs have been made, or if repairs are vital and the landlord does not make them within a reasonable amount of time, have the repairs done and deduct the cost from the rent. If the rent is withheld, it should be put in an escrow account. Such measures should not be undertaken without consulting an attorney first, though. Okay, we already spoke of that, right? And then just put a highlighted box around or highlight the last couple lines in the next paragraph that says where the landlord furnishes heat between October 1 and May 1, it must be at least 68 degrees between 6 and 11 and at least 65 degrees at night. I don't know if they give this to you on exams anymore. I remember I had it back in 2003 when I took my exam, but I don't know if it's still on exams as a question anymore. I haven't heard anybody bring it up that it was. So we did already speak a little bit about assignments. When you assign a lease to someone else, first of all, you can't assign a lease. Most leases state in them that you can't assign them. Now, we already went over that in one of the previous slides. But if the landlord does allow subletting or assignment of their duties to somebody else, well, you're never relieved of the obligation unless they formally novate the contract. So that the primary tenant always holds primary responsibility. Now, truth in renting disclosures. So we already talked about destruction of premises. Termination.
I can check out.
Guys, you want to silence when you're talking? All right. So truth in renting, we're going to be talking about now because we already talked about destruction of the premises and termination of the lease. We spoke about that when we talked about the 4 types of leasehold estates. But with the estate for years, how much notice is needed to terminate at the end of the term? None, because you have an expiration date in there. In a periodic estate, if it's for a period of years, 3 months notice, month to month, 1 month's notice, week to week, 1 week's notice, right?
Yes.
What about tenancy at will? How much notice is needed to terminate?
No.
3 months.
It's 3 months notice. And then tenant at sufferance can be evicted at any time, right?
Mm-hmm.
Yes.
So I want you to put a highlighted box around under termination of lease. You see the bullet points? Put a highlighted box around all those bullet points, which basically runs down that list again, which we already had all together on those slides, though. I put everything together with those leasehold estates. I also added in there for each one what the termination was. Because you do get questions on this on exam. You need to know how much notice is needed to terminate the lease at the end of the term. Okay. And basically the list that I just ran down is right here in this bullet point under termination of a lease. Okay. And then we're going to turn the page and we're going to see truth in renting disclosures. And as we see here on the slide, Truth in Renting, New Jersey Department of Community Affairs, that's the DCA. Okay, so the DCA for short, the New Jersey Department of Community Affairs, requires annual update statements on the rights and duties, or they publish annual updated statements on the rights and duties of residential landlords and tenants. It applies to any residential property requiring the green card, 3+ units, even mobile homes. But it doesn't count the unit the landlord lives in and does not apply to commercial real estate. Okay. So they no longer print this booklet. They publish annual updates of the statements of the rights and duties in residential landlords and tenants in a booklet in the form of a booklet which is no longer printed. Landlords may print copies from the website. Here's a link to it. It's available in English and Spanish. I put a link here for the for it. We can see what this link goes to, what you're going to actually see here. Takes you to the DCA. This is the Department of Community Affairs website. You see the Truth in Renting booklet. You can see the cases here. And a lot of legal services and other information that's available here as well. Okay. And you can see it's available in Spanish as well. And that's this link that I posted down here. So the Truth in Renting booklet, landlords should put like a signature line in the lease showing that it's been given to the tenant, that they've received it, and at least they got the link there, right? Showing that you pointed it out to them. So who do we have to give the Truth in Renting booklet to?
Tenants.
What tenants? Tenants in residential buildings with 3 or more units.
Right.
Yep.
Okay. You'll need to know that. So if you wanted to print under Truth in Renting in page 172, under Truth in Renting, in the second paragraph, you got the links in English and Spanish directly to the booklets in English and Spanish if you want to highlight them there. Okay. This link over here that I gave you takes you to the DCA page, and you could get the links from English and Spanish from that page. And
right.
Basically, this is the Truth in Renting booklet right here.
Yep.
It's updated annually, comes from the DCA, Department of Community Affairs. Talks about all kinds of tenants' rights. This should also be published, and the buildings that require this, not only do you give it to the tenant, this should also be posted somewhere in a public area. Make it available for tenants to read as well, like on a public bulletin board or something like that in the building or complex. It goes over a lot of their rights, the obligations of the landlord, the rights and duties and obligations of the tenant. It's got a bunch of resources. It states the law, the actual laws and codes here. It gives you contacts in all the counties. Legal services for people who can't afford it. Legal services, well, they got legal services that are available here. Here's links and information to anti-discriminatory offices. It's loaded with information and it's updated on a regular basis for all kinds of questions on topics that you may have. Okay, so this is the DCA's Truth in Renting booklet. Okay, DCA. Truth in Renting booklet from DCA. That's 2021. Okay, if you want the actual direct link to that, I mean, I could post that here as well, but yeah, this link goes to it. But here it is again. As small as that 15. There you go. Next. So what tenants do you give the Truth in Renting booklet to?
The residential tenants include the
The,
mobile
s-
home.
the same ones.
Tenants to three or more units.
So it's,
Residential properties with 3 or more units.
so it's the same buildings requiring the green card inspection, right? The state inspection.
Yes.
So more Truth in Renting disclosures. That has to be, they require also the disclosure of the owners, who the owners and property managers are for emergency reasons, you know, emergency purposes. We have to disclose this in the lease, who the owners and managers are. Has to show their names and address, and the residence of the managers must be filed with the local government and state agencies on file too. They must be able to know who the local agencies have to know who the owners of the building are as well.
Victor, you still have you don't have the slideshow window.
I'm sorry. There you go. You have to notify tenants that federal subsidized crime insurance is available in high crime areas through HUD, Department of Housing and Urban Development. The next thing, Americans with Disabilities Act, the ADA. This deals with discrimination as well. This is a law. The ADA was passed in the early 90s. The purpose of the ADA was created to prevent discrimination in the workplace against handicapped persons or against persons with disabilities. All right. Now, more specifically, Title III deals with discrimination in commercial buildings. So it deals with the real estate aspect of it. So Title III of the ADA. First of all, know what the ADA means. It's the Americans with Disabilities Act. Prevents discrimination in the workplace against persons with disabilities. Title III of the ADA prohibits discrimination in what kind of properties?
Commercial.
Commercial buildings, right?
Yes, sir.
By making them handicap accessible. So all new construction must be handicap accessible. That's easy to do before you construct a building, to plan it out that way, right?
Yes.
So generally, it costs a lot less to make a new construction handicap accessible than it would for an existing structure. Existing structure, what is the ADA's recommendation when it comes to existing structures? Well, they say for existing structures, it recommends reasonably achievable accommodations to provide full and equal access to the facilities and services. So what does reasonable mean? It means that as long as those modifications are not expensive or require massive retrofitting. Okay, so reasonable, that's what reasonable is defined as. Okay, so we could add in here that you know, reasonably
Achievable accommodations.
Did I spell something wrong here? Accommodations. Means at little costs without massive retrofitting or undertakings. Okay, so basically, let's go to the Americans with Disabilities Act, and in the third paragraph, highlight Title III of the ADA prohibits discrimination in commercial properties. And then the next paragraph, we're going to highlight to protect owners of existing structures from the massive expense of extensive remodeling. The ADA recommends reasonably achievable accommodations to provide access to the facilities and services.
Good.
All right, and they give some examples here. Lowering payphones, public payphones, if you could still find them. Water, or what about water fountains? You got to lower them? Well, you could actually install a cup dispenser next to them. That's a workaround that they consider a reasonably achievable. Just don't let it run out of cups. You let it run out of cups, you're going to have some ambulance chasing attorney ready to sue you because you're discriminating against a handicapped person because they now have no access to the water. Right? So you got to be careful. You got to be careful with it in that regard.
Right.
Making special parking spaces available. Changing the direction in which doors open, adding wheelchair ramping, etc. These are some examples. Changing the door handles to push door handles instead of grab or twist door handles, where people who don't have hands or have problems with their hands can't grab onto, right? Just making things handicap accessible. That's it. So this is like stuff that should have been in chapter 4. I don't know, it may have been mentioned there a little bit, but this is discrimination. So you can guarantee that you'll get questions about this on exam. Some of those questions can be, what section of the ADA deals with real estate?
Title 3.
And with what kind of properties?
Commercial.
3 apartments or more.
And
commercial building.
No, not 3 apartments or more. Commercial buildings.
Commercial buildings.
Oh, commercial building, that's right.
Not residential. Because they may give you a question and give you examples of different types of buildings and say, which one of these need to be compliant with ADA standards, you know?
Yeah.
Commercial buildings. You know, if they give you an example answer like a multiplex movie theater, well, that's the one. You know, that's commercial property. For existing structures, it recommends reasonably achievable accommodations to make them handicap accessible, right?
Yes.
There you go. Those are the couple possible questions you could get for that. So, rental referral services. Remember this? I think we covered this once before. But before we get to, I think we covered this once before, and we can highlight this. This is the last sentence under rental referral services I want you guys to highlight. That basically goes over what's on this slide. With rental referral agencies, you must check to see if units are still available if they're advertised every day or if they're only listed every 3 days. To see if they still have units available. Because you got to market properties, right? You can't market a property as available if it's not available. So rental referral agencies, they have to check to make sure that if they're advertising units, they need to check to see if they're still available. They have to check every day to see if there's units still available. This is for truth in advertising.
So highlight from which client, please? You want to highlight?
The last sentence under rental referral agencies. Says units that are advertised must be checked every day to see if they're still available. Units that are simply listed must be checked every 3 days.
Okay.
I think we also highlighted that in chapter 3, I believe. I think we went over that in chapter 3 as well.
Yes.
But either way, here we go. We got it again. It doesn't hurt to have it highlighted more than once, right? Now, rent control. What is rent control? Rent control are laws in place to prevent basically slumlords from taking advantage of tenants. This is my definition of it, all right? These laws are set by each municipality. Not all municipalities have them. So you got to check on a case-by-case basis with each municipality to find out what their rules are and if they have rent control. Now, why? Well, because if you guys are puffing and you're trying to sell a property to an investor or anybody really, and you're telling them, wow, check out the rents. This property's priced pretty good. Look at the rents on it. You know, the rents are super low. That's way below market value. You can always jack up the rents here. Be careful. You make a statement like that, you know, statements of fact must be accurate. And you need to find out if they got rent control before you make a statement like that. Because they may be prohibited from raising the rents. That's why the owner's probably dumping the property, because the problem was when you put rules in place like this, like rent control, you put a law in place that everybody has to follow. There's going to be negative consequences to it. So when we don't use common sense and instead we're going to dictate through legislation, we have to put we got to use a little bit of common sense too. If we just dictate through legislation, the downside of it is, you ever hear the road to hell is paved with the best of intentions? Well, that's the case with rent control laws.
Yeah.
You know, it was put into place to prevent slumlords from taking advantage of tenants. However, the negative effect to that is that when these buildings get older, landlords are not able to raise the rents in line with the cost to maintain these buildings. And so now the buildings may be starting to fall apart. The landlord's not going to be reaching in their pocket to pay because, first of all, this property is an investment for them. It's supposed to be bringing them profit. That's what they're living off of, right? That's how they're making money. Now, if they're not getting enough money to even maintain the building, you know, it pretty much turns it into a slum. So the law that was put into place to prevent slumlords is actually creating more of them as the buildings get older. So that's the problem when we try to write in legislation a rule that everybody needs to follow. It's going to negatively affect others, you know. And So then a landlord's just going to eventually look to dump it. And the
So let me ask.
and that may not actually be a good investment to make.
हाँ,
Not,
झरने आ गए भी।
not unless you get
Let me
not unless you
खोलो
get
डोर।
let me
what?
let me ask you this question, because this is a scenario that actually fell onto me.
Unless you tear this
Where I
down and build new construction, it's not going to be worth it. But
where I reside and it's very quiet, very clean, an apartment building with 21 units. Okay.
hold on one
The
second. Let me mute that. There's a lot of noise going on. Hold on. Go ahead.
The previous owner sold the property to a new owner. The new owner, for the first couple months, my rent was still the same. And then I ended up receiving a letter stating, according to a statute law and by the surrounding area of apartments, the average rent, he raised my rent practically almost like 20%. Now, I did bring it to my attorney's attention, because to my understanding, they can only raise the rent by 5%, give or take. But I was told that if that law was put in, and then if that's going to according to what everything, you know, because he was a new property owner, and it goes to according to what everyone else is renting within the area, that he was within his right. But I was never mentioned that, I was never told that I should go through the township to see what their
Yeah, rent control rules that are dictated by each municipality if they have them. Not all municipalities have them, but if your municipality has rent control, you got to check with your municipality to see what the rules are.
Okay.
They
I'm
could
gonna do
vary
that.
from municipality to municipality. That's why I'm not giving
Yes,
you
sir.
any notes on rent control other than what it is.
Gotcha.
In the book above rent control, just write, rules are set by each municipality.
By where? Rent control?
Yep.
And what is the phrase again? I'm sorry.
Just write, rules are set by each municipality.
Thank you.
So now the next slide's dealing with eviction. There's different kinds of eviction. Okay, eviction, let's talk about constructive eviction first. We're going to highlight the title, constructive eviction, on the next page. And then we're going to go down to the fourth line, and we're going to highlight the premises become uninhabitable. The tenant may claim constructive eviction, move out, and cease paying rent. The tenant must vacate the property before claiming constructive eviction. And then it says to always consult an attorney. Now let's go to the slideshow and let's see a better definition here. Constructive eviction is an action taken by the tenant to legally terminate their lease early when a landlord fails to provide basic services or make essential repairs. The tenant must notify the landlord that there's a problem, first of all. Can't assume that they're reading your mind. And if they don't fix it, they can move out. They can vacate, move out, and stop paying rent, and then notify the landlord that they're going to terminate the lease early due to constructive eviction. Now, seek legal help before taking any action on this. And then the landlord must return all the security deposit. They can't withhold any of it. You are not in breach of contract if you terminate the lease early to constructive eviction. Landlord cannot keep your security deposit. They got to give it back to you. Otherwise, if they don't, then you could sue them for that. So let me give you an example. Let me paint a scenario for you of a constructive eviction. I'm going to give a scenario that I usually give for a girl that I once had as a client. Hold on one second. I'm going to pull up my whiteboard. I'm going to pull up the whiteboard, and we're going to draw you a picture here. Find it's easier to draw you a picture. Once it opens anyway. So anyway, I had a scenario as this is opening up. I had a scenario that came into place where I had a tenant. She was a young single mother, a newborn baby, looking for a place, and I found her a house it was a basement that was converted to an apartment, but it was actually legal. This was in Edison. It was grandfathered. The basement was actually, due to its setup, I guess, and the age, it was grandfathered in as a two-family house, even though it was just a Cape Cod style house with a basement that had an external entrance to it. So basically, the house was set up like this. Let me show you a little picture. All right, so the house was set up like this. Here's the house. And on the external of the house, it had this add-on. It was like a door that you walked in this door and it took you down to the basement, right? So this external door here took you to stairs that led you down to the basement, you know, that led you downstairs. And the situation was, so here we go. Here's this house was 2-story. You had a basement. That's where she lived. Actually, this door should be above ground. You guys get the idea though, right? So anyway, she called me up because she said, listen, the landlord, he's very responsive, but he doesn't talk to you on the phone. He'll only respond by text or email, and he's usually extremely responsive with that. But the problem is she's been calling him, and he hasn't been responding to her. And she's like, Victor, what do I do? I don't know what to do. And I'm like, well, what's the problem? Because keep in mind, I'm no longer involved. I was the listing agent and, for this rental. And then she was also the tenant that I got, and I put her in there because I found that this was a perfect place for her. However, I didn't know this landlord personally. Now, she said, well, I first noticed this, when I was bathing my baby in the tub, with an infant, a newborn, you put them in a plastic tub, but usually you put that plastic tub inside the tub or a sink, and then you bathe them within that plastic tub, right? So she was like, she had the baby in the plastic tub inside the regular tub, and she's bathing the baby there. And she's like, every time they flush the toilet upstairs, it comes out into my tub. That's nasty.
That's disgusting.
What happened was you got the sewer pipe.
That's disgusting.
Let's just say you got the sewer pipe. This is the sewer main, right? And then it goes out to the street. Okay, here's property ends over here. So she's got their tub down here, right?
Yeah, stop hanging out on.
What happens is when you flush the toilet, there was a collapse in the sewer main on his property where it was going to the city sewer main. So the sewer pipe collapsed over here. So every time the water comes out, it hits there, it slowly backs up to the lowest.
Jason, move your foot.
And that lowest point is the tub in her basement. So every time they flush the toilet, it would come out, it would hit this collapsed pipe, and then it would back up into her tub and then slowly drain out. I would be fuming, if I'm bathing my newborn and that starts coming out in my tub, or you're taking a shower. That's disgusting. I would definitely say that passes as an uninhabitable condition, wouldn't you? So
Yes, without a doubt.
So
yes, of course.
So
Yes.
so what she called me up and she's like, well, what do I do? And I was like, well, can you document? I mean, how long have you been trying to reach out to the landlord? She's like, I've been trying to reach out to him for weeks now, and he knows the problem. I know he's getting it because I've been emailing him, I've been texting him, and I know he's getting it. And she's like, I was like, okay, well, do you have anybody that you could temporarily move in with? And she's like, well, I got a girlfriend that I can, and then we could find a new place for her. I was like, okay, well, first let's, if you have any documentation, first archive that documentation, print it if at all possible. And the first step I would suggest that you do would be to go down to City Hall. In Edison, who controls the rentals? It's the health department. So I told her, step one, go to the health department.
Nice.
And file a complaint with them. Then step two, I said, you got to move out. Move out with your girlfriend. I'll find you something. I'll work on trying to find you something. And step three, notify the landlord that you're moving out due to constructive eviction. And that you want your security deposit back. And I said, but before you do this, this is legal advice. I don't want to steer you wrong. I gave her the number of an attorney to call. I said, call him up first before you do anything, just to make sure I'm giving you the right directions, because this is legal advice and I'm not an attorney. So before you do anything, I don't want you getting in trouble. Make sure you talk to the attorney, please. Don't do anything until you talk to the attorney first. He's not going to charge you for it. He'll just give you that advice over the phone. Okay. Just tell him I asked you to call, and that you just want to make sure that you're doing things in the right way. So he confirmed. I told her to do things the right way. And so she did that. She went down to the health department and she filed the complaint. And, she's like, they looked up who it was. And she told me, she's like, when they looked up,
Can't hear you, Vic. For some reason,
Can't hear
You
you.
kind of couldn't hear you either.
What's the matter?
It's like frozen.
Yep.
Let me
Where are you?
maybe.
Where are you, Vic?
Uh-oh.
Hello.
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 Can't hear you,
Vic has
Vic.
disappeared.
Yes,
Oh
Vic,
boy.
you are
He
done.
hit the wrong mute button.
He touched the wrong thing. He had to come back out and back again.
Can see.
Lilian, you tell me where? You next to the pool, Lilian?
Yeah, can you tell?
I can see
I'm
that.
watching my grandkids.
Oh my God, look at that.
I got 4 of them.
Oh my goodness, you would never know.
Yeah, chlorine in the pool, so now they got to use the slip and slide.
Oh, oh God, we really lost him.
Mm-hmm.
Uh-oh, something's going on. He's got.
He's still stuck, right?
I know, right?
Yeah, it seems like Victor froze up.
Uh-oh.
Just when the story was getting nice.
Yeah.
He tried to do something. You see, he tried to do something.
Yeah, I see him, yeah, right?
He
See the
see his
arrow?
arrow. Yeah, he tried to do something with his arrow.
I'm sure he's pissed.
Oh, I think he's crazy right now trying to.
Oh, yes. Oh, I can imagine. Oh my God.
Look at his screen.
I know.
I know. Whatever he has to do, I think he.
Yeah, that's true.